back in antiquity, they would walk about 190 miles in 5 days. Okay, not that I expect that of you, but
Your
it's
Honor,
doable.
I believe the discrepancy is defendant has advised that he's being transported back to Indian River. So
Right.
that's why he's confused as if it's 5 days from his transport or 5 days from his sentence in India.
Okay, and that's why I indicated 5 days from your release from custody, whenever that might be. So you don't have a duty to be here within 5 days as long as the state has you in their custody and you can't go anywhere. But once you taste the sweet fragrance of liberty, then you need to make your way back to Osceola County. I'll tell you what, I'll give you 10 days, all right? 10 days to report to the Osceola County Clerk of Court to make a payment arrangement.
Thank you.
All right, good luck to you. Thank you.
Yes, sir.
All right, let's go to Edwin Geraldo Hernandez.
Admin Usage for the Public Defender's Office. Your Honor, we will need a Spanish interpreter for this matter.
All right, I think that was a mixed metaphor. You don't taste fragrances, but I'm going to go with it. We're going to come back to this case in just a few minutes.
Your Honor, may I ask if state does have an offer on this case?
Yes.
So I can convey it?
Your Honor, there's no offer at this time. The defendant does have two other open cases, one being a DUI and another being a no valid DL. So there's no offer at this time.
There's no offer. I'm happy to summon the interpreter, but if you know it's a not guilty plea and you wanted to waive arraignment, you could do that too. It's up to you.
Your Honor, we'll waive a formal arraignment, enter a plea of not guilty on his behalf.
All right, not guilty plea is entered in 21 CT 389.
Actually, there was a
Thank you, Your Honor.
NOA filed yesterday.
Okay.
It's already set for pre-trial on April the 20th.
Mr. Usich, for your own information, and it just discovered that a private counsel, let's see, I recognize that typeset. Who is that? Okay, so private counsel filed a notice of appearance yesterday or the day before and went ahead and entered a not guilty plea waiver of arraignment. So it's been set for private pretrial conference, and the public defender will be withdrawn if you were previously appointed.
Thank you, Your Honor.
All right, thank you. Nicholas Gomez.
Good morning, Your Honor. Yvonne Antonin on behalf of the defense.
Good morning.
Good morning, Mr. Gomez. This has been docketed for plea. Is it still a plea, counsel?
Yes, Your Honor. We will be entering into a negotiated plea of adjudication of guilt, credit time served, reserve restitution, and court costs.
Okay, and how is your client going to plea?
I'm sorry, can you hear me?
Yes, yeah.
Sorry, we will be entering into a negotiated plea of the anticipated disposition at which he has already signed. Can you hear me?
I can. I heard it was a negotiated plea, but how will your client be pleading?
Oh, he will be entering a no contest plea today.
Got it. All right.
Of adjudication of guilt, court cost, credit time served, and reserve restitution.
Mr. Gomez, if you're in agreement, please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can put your hand down. Mr. Gomez, some questions. Did you sign the plea form?
Yes, I did.
Before signing the plea form, did you read and understand it?
Yes, I did.
Did you have a good chance to talk to your lawyer about this decision?
Yes, sir.
You understand if you're not a United States citizen, this plea will subject you to deportation.
Yes, I do.
Under the influence of any drugs, alcohol, or medication?
No, I'm not.
By entering this plea, you're giving up your right to have a jury trial. Do you understand that?
Yes, I understand.
Based on these understandings, do you wish to plead no contest to, and it's a 2-count information, counsel, so he's pleading to both, is that correct? There's a criminal mischief charge, and then there's a possession of drug paraphernalia charge.
Yes, Your Honor, that was the state's understanding.
Yes, Your Honor, that's a defense understanding.
And is that your understanding, Mr. Gomez?
Yes, sir.
So to make it clear then, do you wish to plead no contest to criminal mischief as alleged, as well as possession of drug paraphernalia?
Yes, I do.
All right, and I would like to hear the factual basis for this, State.
Yes, Your Honor. On January 18th, 2020, law enforcement was on routine patrol in the area of Vineland Road and Osceola Parkway in Osceola County, Florida, when the officer observed a silver Mercury Grand Marquis parked in the middle of the roadway leading from the Publix Plaza towards Osceola Parkway. Inside the vehicle were 3 male occupants. One male was sitting in the front driver's seat of the vehicle, who was later identified as Darby Lance Wood. Another male was sitting in the rear passenger seat, later identified as Nicholas Gomez. An additional male was sitting in the rear middle seat, who was later identified as Brian Morrison. As law enforcement approached the passenger side of the vehicle, he began speaking with Mr. Wood, and while speaking with him, he observed a small plastic baggie sitting on a towel on the seat next to the driver's right hand. The baggie contained a clear, white, crystalline substance that he recognized as methamphetamine. While speaking with the driver, he also observed Mr. Gomez to be reaching towards the middle of the back seat with a bulbous-shaped object in his hand. The officer then called for backup units and had the occupants exit the vehicle. Once the occupants were out, he was able to see the object in Mr. Gomez's hand was a glass smoking device with a bulbous round end that is commonly used for smoking methamphetamine. The pipe had visible residue as if it had already been used to smoke methamphetamine. Additional law enforcement then arrived on scene and took over the investigation. While attempting to identify the backseat passenger, who was later identified as Nicholas Gomez, he continuously stated his name was Chad Lopez, DOB, March 19th, 1994. After approximately 20 minutes of attempting to positively identify him, he then stated his name was Nicholas Gomez, DOB, March 19th, 1996, and that he had a warrant out of Seminole County. Law enforcement noted that while in the back seat of a law enforcement vehicle, Nicholas began to pry the inside of the door open and damage the rear driver's side interior door panel. He caused several of the wires to be damaged and broken. When asked why he broke the door panel, he stated he was trying to get the door open. All events occurred in Osceola County, Florida.
And state, you don't have an affidavit yet from the agency concerning the amount of restitution?
Not an affidavit, Your Honor, just an estimation of the damage.
All right. Okay, Mr. Gomez, I accept your pleas of no contest with respect to count 1, criminal mischief, damage more than $200. I will adjudicate you guilty, sentenced to 59 days in the Osceola County Jail. With credit for the 59 days you've served, the court will reserve jurisdiction for restitution should the state come forward with that information. You would be entitled to a hearing on the amount, but I will reserve jurisdiction for that purpose. On count 2, possession of drug paraphernalia, I will accept your plea of no contest, adjudicate you guilty, sentenced to 59 days in the Osceola County Jail to run concurrent with count 1. There are mandatory court costs of $388, a $100 cost for the services of the public defender for a total of $488. Mr. Gomez, as part of your sentence, you have to report to the Clerk of Courts Collections Department on the second floor of the courthouse within 5 days of release to make a monthly payment plan for this obligation. If you don't show up, if you just blow it off and don't come to the courthouse within 5 days, then you can incur additional sanction, including contempt of court for violating your sentence. So just make sure you show up. They'll make out a payment plan. You have 30 days to appeal. There'll be a fingerprinting. You'll be released on this case today, subject to any other holds that you might have. Did you have any questions about the sentence?
Yeah, I originally bonded out for like $300. Can that be applied to my court costs?
It was was it a surety?
It was a cash bond and it was streeted back in.
Okay, when you FTA'd, your bond was estreated, so it's no longer available. Good question, but the answer is no.
Your Honor,
Yes.
Your Honor, if I may, I do see an invoice for the damage from the Osceola County Sheriff Fleet Maintenance Facility. I'm not sure if that suffices as,
Has it been provided in discovery to the defense?
No, Your Honor.
okay, we can provide that for discovery.
All right, well,
Handle that at a later date.
and I'll just, Mr. Gomez and counsel, I mean, typically, I don't want to say typically, but in many instances, once the invoice is provided, counsel will have a chance to look it over. Sometimes the parties agree to the amount, otherwise we can set it for a hearing. But it'll be up to the state to set that for hearing if necessary.
Okay, I do see that it was sent to the Public Defender Stack System, so I believe that Ms. Antonian does have access to it. But if not, we can handle it at a later date.
I'm going to amend the judgment. I'm going to order restitution and reserve jurisdiction to determine the proper amount.
Thank you, Your Honor.
Okay, very good, Mr. Gomez. Thank you. He'll need to be a fingerprinting. Kenneth Goodwin.
Admiral uses for the defense.
21 CT 429, driving under the influence or DUI. Mr. Usich?
Your Honor, he would like to know if there is an offer available.
There's not an offer at this time, Your Honor. We're still waiting on the defendant's driver's license record from Georgia.
Yes, Yes, Your Honor, we'll be entering a plea of not guilty today.
All right, one moment. Okay, a not guilty plea is entered on 21 CT 429. The case will be set for pretrial conference, Mr. Goodwin, on the following date and time.
Trial set for April 21st at 9:30.
Now, there's one other matter, and information's probably not been filed, but let's take a fresh real-time look at case 21 MM 362, resisting without violence, still not filed, so that'll just have to be set once an information is filed and prosecution is commenced. Mr. Goodwin, thank you. Eddie Marrero Ramos.
Your Honor, admin usage for the defense, we will need an interpreter for this case. There's a plea debate that we're taking.
Okay, all right, just one moment before I summon the interpreter. What was the anticipated disposition?
Yes, Your Honor, it's an admission to the VOP, 15 days Osceola County Jail with credit time served for 12. Revoke and terminate probation, $200 in back costs and court costs.
Okay, I'm going to come back to this case. I'm going to run through the rest of our docket if he'll remain in the courtroom so I can take them all at the same time so I don't have to keep calling the interpreter. Okay, thank you. Vince Martinez Quinones.
Admin usage for the defense.
Morning, sir. Step right up to the mic. All right, your date of birth?
2281.
Mr. Martinez Quinones, you've been accused of violating probation, placed on probation for driving under the influence. The allegation is that you failed to report to probation within 24 hours of release. You were put on probation on November 5th of 2020. Just one moment. And it appears everything is outstanding. So according to the allegation, nothing's been done on probation. Let me turn to Mr. Usich.
Yes, Your Honor, we'll enter a denial as to the violation of probation.
Okay, a denial is entered, and this case will be set for violation of probation on the hearing on the following date and time, or status, whatever they do. Yeah.
VOP status set for March 18th at 1:30.
All right, that's your next court date, sir, in another division. Thank you. Eugenio Perez. Good morning, Mr. Perez. Your date of birth?
0609-1981, sir.
All right, sir. You were placed on probation for driving under the influence. The allegation is that you failed to report for scheduled appointments, failed to pay cost of supervision, failed to pay fines, failed to satisfy the immobilization requirement, failed to enroll in and complete the drug and alcohol evaluation and any recommended treatment, failed to complete the DUI classes, and it looks like, just a moment, looks like there's some allegations that are open and pending in Lake County. The public defender's been appointed to represent you. You have the right to a hearing where the state would have to prove these allegations by a preponderance of the evidence on a VOP to the court's satisfaction. Mr. Usich.
Yes, Your Honor, we'll enter a denial as to the violation of probation.
A denial is entered. This matter will be set for hearing in another division on the following date and time.
VOP status hearing set for March 18th at 1:30.
Thank you. Jesus Principe. I'm trying to say that.
Hello, Your Honor, Yvonne Antonian. He is still in custody in Seminole County. We'll just be asking for this matter to be reset.
Okay. Just a second. Let me take a look here. 20 mm, 17. Oh, docket sounding. Is that what DS means? Okay. Okay, we will, I'm just going to reset the jail arraignment and ask the state to provide a transport order for the defendant. He's apparently in Seminole County. That's 20 CT 2541. We'll set him out 2 weeks.
March 11th.
All right. Michael Quinones. Michael Quinones.
He is in a COVID hold right now, Your Honor.
Okay, then we'll set him out 1 week in 21 CT 446.
March 4th.
All right, unless counsel knows of whether, I don't know if you're in a position to waive arraignment.
I'm not his attorney, Your Honor.
Okay, all right. It'll be as just announced. Deshaun Roberts.
He is in custody in Orange County. So
Okay.
we'll be asking to reset this as well.
Did you get that info from corrections?
Yes, I just got that info from correct.
All right, so 21 MM 199, it's just an adjacent county. We'll set it for next Thursday for jail arraignments, and state if you could get a and a proposed transport order.
Yes, Your Honor.
If we get that out today or tomorrow, it should be, we should be able to get it done. So that'll be set for next week.
March 4th.
Elvin Rodriguez Roman, 20,
Sorry, Your Honor, he is in a COVID hold here in custody.
all right, 21 CT 251 will be set, I'm going to set it out 2 weeks with the COVID hold. Probably should
March
have.
11th.
March 11th. To be reset. Anthony Scott, 20 CT 3376 and 21 MM 419. Mr. Scott.
Yes, Your Honor, Yvonne Antonian, he is present.
All right, Mr. Scott, your date of birth?
There's a little big mix-up, Your Honor. The date of birth that I have here at the Osceola County Jail is not my date of birth. My date of birth on my birth certificate, on my driver's license, on my social security is 12/24/1972, sir.
Okay, so here's the way this will work. I'm going to go ahead and place you under oath. If you could please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. This is an official proceeding in a criminal case, and the reason that's important is so that you understand that it's imperative, it's important that what you say is accurate and truthful. Otherwise, it would be subject to a 5-year prison sentence for perjury if you gave false information. Not that I think you're going to do that, I just have to tell you that, all right? All right, so what is your true legal date of birth?
My true legal date of birth is December 24th, 1972.
Okay, and state, we have information on our docket from the case, and according to the citation that the officer issued of a 10/5/72 date of birth, how do you wish to proceed with the date of birth announced by the defendant or the one on the docket?
We would proceed with the DOB announced by the defendant.
All right, so the date of birth will be amended according to the state's request to 12/24/72. And we would list an alternative, AKA date of birth of 10/5/72, for which there are several cases in our system. And I would ask corrections. The prints, he was booked obviously on this case. Has there been a print comparison sent to the FBI?
I'm not aware of that, Your Honor. If you would give me 1 minute to confer with corrections. They will inquire with bookings. The officers here are not aware of such information.
Okay, given the discrepancies and what I'm seeing in benchmark, yeah, I would ask that they check that with the database. Keep that there. Mr. Scott. Mr. Scott, when you filled out your application for the Public Defender's Office back on February the 5th, you signed a document which says this: a person who knowingly provides false information to the clerk or the court in seeking a determination of indigency status commits a misdemeanor of the first degree, punishable as provided in Florida statutes. I attest that the information I have provided on this application is true and correct, and you signed your date of birth as 10/3/72.
Okay, can I, Your Honor, when I first came in here, I was listed as John Doe, first of all, my first 24 hours here. I slept through the whole day until I was given a PTR. The day they gave me the PTR, I don't remember the name, but somebody just said, leave today as Anthony Scott. And thank God I was able to provide my attorney, Mrs. Jessica Nadal, my valid driver's license with my social security. And I don't know if the prosecution office has that right now, but, you know, that's what I did, you know, at the moment. And then I got rearrested. And when the sheriff asked me my real name, I said, my name is Eric Elijah Scott. He looked me up on Facebook. He saw the picture of my ID, and he said, is that you? I said, yes. He put the cuffs on me. I should be on video camera on this. And I came here with that. I've been here with Anthony Scott the whole time. And
No, I'm just making inquiry because you wrote your date of birth 10/3/72 on the application that I'm looking at right now.
I don't know where that birthday came from, but that's not my birthday.
It came from your hand.
Your Honor, I don't remember that. I probably was still under the influence when I first came in here, sir.
Well, then you'll need to resubmit an application while you're clear-headed. So I'm going to withdraw the public defender's office from this case. You'll need to fill out a new application. A not guilty plea will be entered on behalf of the defendant in the providing false identification to law enforcement. That's one charge in 21 MM 419. That is a case that's punishable by up to a year in jail and a $1,000 fine. No valid driver's license, second-degree misdemeanor, maximum fine $500. Just one moment.
Judge, that case that you're speaking about right now, that was a direct information. It doesn't have any attorney on it. The one I showed you, an information has not been filed, but there was a PD application filed on that 234. That's not on our docket.
Okay.
Even though the CT case, 33716, that is on our docket, or 3376, the PD
Your Honor,
application was,
information has
Just a minute, I'm sorry.
the PD application was also filed on that 3376. So
Okay.
not on the 419. The 419, it was a direct information.
Okay. All right, you were going to say, Ms. Antonia?
Yes, Corrections has sent information with the name, but not the fingerprints to FBI.
Okay. All right, so not guilty pleas will be entered in each of these two cases. The defendant will need to resubmit an application because he's indicated to the court that he might have been still under the influence of something such that he was not thinking right when he completed the existing application. And once the court receives that updated application, it can make a judgment on counsel. Defendant's currently unrepresented, not guilty pleas entered, pretrial conference as follows.
April 13th, 8:15.
All right, thank you, sir.
Thank you.
Jocelyn Velasquez. Oops, I skipped a page. That's okay. All right. This is 21 CT 198. Good morning. Ms. Velasquez, your date of birth? Okay, you've been accused of operating a motor vehicle at a time when you knew that your privileges were suspended, canceled, or revoked. It's further alleged that you have 2 prior convictions for driving while license suspended. All right, and that carries with it a 10-day minimum mandatory. I see that there's a case that's set for jury trial in 20 CT 1922. Okay, at Dwellis. And 20 CT 2300 set for pretrial on March 9th at Dwellis. Counsel?
Your Honor, at this point, we'd be entering a plea of not guilty.
Not guilty plea is entered. Ms. Velasquez, your case will be set for a new court date of pretrial conference as follows.
April the 12th at 9:45.
That's your next court date. Thank you. Gregory Youssef.
Your Honor, he is also being quarantined for COVID.
Okay, we'll set him 2 weeks out just to be safe. 2 weeks out, 21 MM 441.
March 11th.
March 11th.
Thank you, Your Honor.
Yeah, 7 days out. Let's set it 2 weeks. We're gonna change the date on one of those prior COVID situations to be announced momentarily.
March 11th.
Which case?
I'm sorry.
That's right.
21 CT 446, Michael Quinones,
Okay.
March 11th.
Okay, so Quinones went from the 4th to the 11th. Let's go to Jermaine Small. Jermaine Small.
Your Honor, he's currently in Clay County Jail.
Yes, I see that. It's an alleged violation of probation. Let's go ahead and set him out 2 weeks for jail arraignment and state if you could provide a transport order.
And the transport order was provided February the 12th.
Okay, apparently that motion was denied, right? All right, so we'll just seek another transport order. Sometimes if they've got a hold and it's a felony or they
Yes, Your Honor, for
take
the
care of
court's
that.
information, there is an open felony in Clay County.
Okay, all right, but we'll still we'll need to continue to request him because when he's in state custody, Speedy typically continues to run, but this is a violation of probation, so that's not an issue. Joshua Valier Martinez.
Your Honor, he also has COVID and is being quarantined.
Okay, so on the Valle Martinez case, we'll set it for March 11th for jail arraignments. Okay, let me go back. I think we had an interpreter matter or two. Maybe just one. Yeah. Which assistant public defender is representing defendant Eddie Marrero?
Tiana Carabello on behalf of Mr. Marrero.
Ms. Caraballo, before I summon the interpreter, what is the anticipated dispo? You say 15 days, if I recall?
Yes, Your Honor.
Okay, let me call the interpreter, and he can come forward.
Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter, already previously sworn.
Okay, Ms. Arroyo, we're of course in jail arraignments, and
Yes, Your Honor.
I just want to make sure that everyone is hearing everyone okay. Bless you, Ms. Caraballo. Times two. Can you hear Ms. Arroyo? Did you hear Ms. Arroyo's announcement? Okay. The case number, Ms. Arroyo, is 2019 MM397, State of Florida versus Eddie Marrero Ramos, who is standing before the court. So we'll begin now. Mr. Marrero, can you tell me your date of birth?
Señor Marrero, ¿me podría usted indicar su fecha de nacimiento? 12-5-7-3.
Mr. Marrero, we're here today for an arraignment on a violation of probation.
Señor Marrero, nos encontramos aquí para la vista incoatoria con respecto al acto de incumplimiento del régimen de libertad vigilada.
Underlying charge, possession of drug paraphernalia. Your attorney has indicated that you wish to waive arraignment and proceed to admit the violation of probation. Is that true?
Por una acusación original de tenencia de artículos de droga, y la abogada suya ha indicado que usted desea renunciar a la celebración de la vista incoatoria y que en vez desea proceder directamente a la admisión de su incumplimiento del régimen. ¿Es cierto eso? Yes.
And Ms. Caraballo, now that we have the interpreter, could you again just put the terms on the record?
Licenciada Caraballo, ya que tenemos ahora un intérprete, por favor, podría hacer constar en actas los términos del convenio.
Yes, Your Honor. The terms are 15 days Osceola County Jail, revoke and terminate, $200 back costs of cost of supervision, and then the court costs, Your Honor.
Sí, su señoría, sería 15 años de 15 días de encarcelamiento, revocar y poner fin al régimen de libertad vigilada, imponer $200 de costas de supervisión atrasados y costas judiciales.
All right. Something was humorous beyond my comprehension.
Your Honor, that the interpreter caught herself midstream. She said years and corrected herself
okay.
2 days.
Well, that might be humorous to some and not others. All right. State, is this your understanding of the agreement?
¿Eso fue lo que la Fiscalía acordó con respecto al acuerdo?
Yes, Your Honor.
Yes.
Mr. Marrero, please raise your right hand to be sworn.
Señor Marrero, por favor levante la mano derecha para prestar juramento.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura y promete que la declaración que rendirá será la verdad, toda la verdad y más que la verdad. ¿Lo jura ante Dios? Yes.
You can put your hand down.
Ya puede bajar la mano.
Mr. Marrero, did you sign the admission form in this case?
Señor Marrero, ¿firmó usted el formulario de admisión en la presente causa? Yes.
Before signing it, did you read and understand it?
Antes de firmarlo, ¿lo leyó y lo entendió? Yes.
Did you have a good chance to talk to your lawyer about this decision?
¿Ha tenido usted la debida oportunidad de poder consultar con la abogada con respecto a su decisión? Yes.
If not a United States citizen, do you understand this admission would subject you to deportation?
Si usted no es ciudadano de los Estados Unidos, ¿ha entendido que el presentar esta declaración de admisión resultaría en su deportación? Yes.
Are you under the influence of any drugs, alcohol, or medication today?
¿Se encuentra usted hoy día bajo los efectos de algún tipo de droga, medicamento o alcohol? No.
And finally, do you understand by admitting the violation, you're giving up your right to have a hearing where the state would have to prove you willfully violated?
Y por último, ha entendido que al presentar esta declaración de incumplimiento de su régimen estaría renunciando a que se celebre una audiencia donde le tocaría a la Fiscalía tener que demostrar que usted manifiestamente incumplió con su régimen. Yes.
Do you admit that you willfully violated your probation by failing to report for scheduled appointments, failing to complete community service hours, failing to pay your monetary obligations, and finally failing to complete your substance abuse evaluation and treatment?
¿Usted está dispuesto a presentar una declaración de admisión por incumplimiento de su régimen al faltar en comparecer ante cada una de las citas fijadas, al no cumplir con las horas de servicio comunitario, al no cumplir con pagar su obligación monetaria y someterse a una evaluación de sustancia y tratamiento? Yes.
Mr. Marrero, I accept your admission to the violation, adjudicate you guilty, sentence you to 15 days in the Osceola County Jail with credit for the 13 days you've served.
Muy bien, señor, se acepta su declaración de admisión por incumplimiento de su régimen. Se impone dictamen de culpabilidad con 15 días de cárcel y acreditado los 13 días cumplidos.
You must pay $200 to Osceola County Probation for your back cost of supervision within 90 days of your release from custody.
Usted tendrá que pagar $200 a la Oficina de la Libertad Vigilada por costas impagadas y tiene un plazo de 90 días una vez que se ha puesto en libertad.
You still owe $488 in fines, along with a $100 cost for the public defender for the violation of probation, grand total $588.
Usted todavía va a deber unas multas de $488 más $100 en horarios de defensor público por esta acusación de incumplimiento, un monto total de $588.
As part of your sentence today, you must report to the Clerk of Courts Collections Department within 5 days to make a monthly payment plan for this obligation.
Como parte de la sentencia hoy día, le toca a usted reportarse a la oficina de cobro de la Secretaría del Juzgado. Tendrá un plazo de 5 días para establecer un plan de pago mensual.
That's the second floor of the Osceola County Courthouse within 5 days.
Eso sería en el segundo piso del Juzgado de Osceola y dentro de un plazo de 5 días. Okay.
Your probation is revoked and terminated. You have 30 days to appeal.
Se revoca y se pone fin al régimen de libertad vigilada. Usted tiene un plazo de 30 días para poder apelar.
There'll be a fingerprinting. Good luck. Thank you.
Le van a tomar sus huellas digitales y buena suerte. Gracias.
All right. Thank you, Ms. Arroyo.
You're welcome. The interpreter will disconnect.
Thank you. Okay. Okay, I think we've concluded our 8:30 docket. Let me just make a brief inquiry. By chance, is Nigel Carr in the courtroom and ready to plea?
Yes, Your Honor, he is.
Let's have Mr. Carr come forward. It's scheduled for 10, but we might as well take care of it.
And Your Honor, ASA card is here for Mr. Brown's plea.
Okay, we'll turn to that next. He just walked out though, right?
He just walked out.
Good morning, sir.
Good morning, Mr. Carr. Your attorney's indicated that you're ready to plea today, so if you could please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Ms. Caraballo, the anticipated disposition.
Your Honor, the anticipated disposition is an adjudication of guilt, credit for time served, and court costs.
Is that the state's understanding?
Yes, Your Honor.
Is that your understanding, Mr. Carr?
Yes, sir.
Before proceeding further, criminal history, Mr. Lentz?
Yes, one moment, Your Honor.
I'll take the Brown case next, Mr. Carr. So it'll be a couple minutes. Was he going to do virtual?
And Your Honor, I see that the defendant in this case was convicted of a grand theft subsequent to this offense date on case number 19 CF 9328. That case is out of Duval County. Hence the basis for the plea.
I just wanted the exhaustive theft, any other theft history.
I do see 2 cases, but those were dropped. They were for petty theft as well. And I also see, Your Honor, a grand theft in 2010, and this is the last theft that I do see. It is Leon County, 2010, CF 2915. There was a withhold of adjudication on a grand theft, greater than 300 but less than 5,000.
Okay, so 2 prior grand thefts. Was the first grand theft you referenced an adjudication of guilt?
The first one was a withhold of adjudication. The second one, which was subsequent to this event, this case number, Your Honor, in 17MM, was a adjudication of guilt, and that was in 2019.
Okay. All right, Mr. Carr, from the court's perspective, you're getting a pretty good resolution here on this matter. I understand that the one you referenced that where there was an adjudication was subsequent to this, but the bottom line is you're standing before the court as a convicted felon on a theft and another prior theft. So this is a pretty good disposition on your part. Hopefully you can put all this behind you and move in a positive direction. The penalties typically get progressively worse for repeat offenses, all right? I know this is an older case, and, you know, hopefully it's in the past for good. Please raise your right hand. Or we already swore you in, didn't we?
Yes, sir.
Mr. Carr, did you sign the plea form?
Yes, sir.
Before signing it, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you have a good chance to talk to your lawyer about this decision?
Yes, sir.
If you're not a United States citizen, do you understand this plea would subject you to deportation?
Yes, sir.
Under the influence of any drugs, alcohol, or medication today?
No, sir.
Do you understand by entering this plea of no contest, you're giving up your right to a jury trial?
Yes, sir.
Understanding these rights and consequences, do you wish to plead no contest to theft of property $100 or more in value?
Yes, sir.
State have a brief factual basis?
Yes, Your Honor. On July 9th of 2017, the defendant entered Plato's Closet and was identified by the store manager as Mr. Nigel Carr. Surveillance video showed Mr. Carr obtain $121 worth of merchandise and exit all points of sale without paying. Investigative techniques, including tracking down the owner of the vehicle, Mr. Carr, were utilized. Mr. Carr was then identified by law enforcement as the individual that committed the theft at Plato's Closet. All events occurred in Osceola County, Florida.
All right, based upon the state's recital of facts in this case, Mr. Carr, along with my reading of the police report, I find an adequate factual basis to accept your plea of no contest. I accept your plea of no contest to theft over $100 in value, adjudicate you guilty, and sentence you to 25 days in the Osceola County Jail with credit for the 25 days you've served. Court costs are $273 and a $100 cost for the services of the public defender for a total of $373. I'm ordering that you report to the Clerk of Courts Collections Department within 5 days of your release from custody for the purpose of making a monthly payment plan for this obligation. If you don't show up, it would violate your sentence and could subject you to further sanction. Also, Mr. Carr, you're not to return to the Plato's Closet located at 1624 West Osceola Parkway. State, was there any restitution in this matter?
Yes, Your Honor, there is restitution. The state would be asking for an order and a reserve on the restitution amount. The charging affidavit does state that the defendant did obtain and pass all points of sale with, I believe it was $121. The state would just be asking for an order and a reserve on restitution.
Ms. Caraballo?
No objection, Your Honor.
Yeah, I'll order restitution and reserve jurisdiction if the state seeks further action on flushing that out. Reserve jurisdiction for amount. Mr. Carr, again, 30 days to appeal. There'll be a fingerprinting, and you'll be released on this case today, subject to any other holds that you might have. All right?
Yes, sir.
Good luck. Thank you. All right, let's see. We had another plea also. She's out of custody though. Let's see. All right, folks, we'll be in recess for about 20 minutes. We'll be unless you had a matter we can address.
Your Honor, I do have the Campbell and Burton status
Well,
hearings and competency.
let's take up Campbell. James Campbell, that's 2019, actually, 2019 MM 1874, 2013 2829, 3463, and 20 MM 1240.
Is also Campbell.
Okay, and then there's one that's docketed for 11 o'clock, 21 MM 59. I did review case number 2019 CF 361 prior to coming to court today, which is a case that we were tracking. So I'll just afford both parties an opportunity to be heard. Ms. Reed?
Yes, defense is asking for continuing findings of incompetency. As stated previously, the defendant has issues where the situation that he has mentally cannot be restored. According to the Montreal Cognitive Assessment, which is a test to develop the detected levels of cognitive impairment, he scored a 13 out of possible 30, which is signs of dementia, and that score increasingly gets lower every time he is tested. The doctor also implies that he cannot be restored because this is a cognitive issue, and he has neurocognitive disorder, causing a lack of sufficient present ability to consult with his attorney with a reasonable degree of rational understanding. With this being said, defense is asking that competency status remains and he's incompetent, and we're also asking for a dismissal.
Mr. Lentz?
Yes, Your Honor. The state is just asking that this continues to track 19 CF 361. I see that they have a status date on April 7th for a competency status hearing. He did go through a second competency eval, but apparently, according to that evaluation, sign language was a barrier. I believe that they are going through the process of looking forward to see if they can get another evaluation for his 19 CF 361 case. The state is just asking for a continuation of tracking for that April 7th date.
All right, well, on February the 22nd, Judge Tom Young, scheduled it, as we've all said, for competency status hearing on April the 7th of 2021. However, in the body of that order, he said that the defense is to submit an order or to prepare a conditional release conditions by the end of business day today concerning all conditions of release placed on the record by the court. That has not happened. At least there's not an order. I did send an email to Judge Young this morning alerting him to the fact that we're tracking his case and that I need to have that articulated. Given all the circumstances here, multiple consecutive criminal cases over and over and over again, I want to have some meaningful conditions of release before releasing Mr. Campbell.
Your Honor, I can reach out to the PDs in the felony court or the circuit court and try to get an understanding of where they are with that.
Yep. I'm going to go off record just a minute. And Ms. Reed, you said that you were asking me to continue the finding of incompetency.
Because there is another case, 21 CT, I'm sorry, where I did file a motion to continue the findings.
Right, I'm just want which cart we're hitching our wagon to? Which finding of incompetency are you referencing, and what is the date of the finding?
I apologize, Your Honor. I do have that on my computer with my notes for the case, but unfortunately, I do not have that in the courtroom today. But the case I'm asking for the motion is 21 MM 059. He was declared incompetent from case 19 CF 361 from Skowinski's evaluation, and that was the incompetency finding that I was asking to be continued.
All right. Well, since the circuit court that we're tracking is still exploring the question of competency, by virtue of our procedure of tracking, we are doing the same. So that case was set for April the 7th. We're going to set a competency status hearing about a week after April the 7th. So to make sure that whatever occurs on the 7th is memorialized in benchmark. And I'm not taking any action in terms of releasing Mr. Campbell until I receive the conditional release order in the 19 CF 361. Yeah.
Here's this one that says the defendant is hereby deemed incompetent to stand trial.
What's the date? June 28th. Yeah, it's too old.
Yeah.
Yeah. Okay. Yeah, I found one where I found him, the defendant, incompetent back in 2019, almost 2 years. Well, a little over a year and a half ago. That's too stale to make a definitive determination on today. So we're tracking the other case. We're going to keep tracking it. And Ms. Reed, that conditional release order was to have been provided a few days ago. Maybe it's in flux. So as soon as you provide that to the court would likely adopt that conditional release order as to all of the cases on our docket today.
Yes, I will reach out to the APDs in circuit as soon as I get back to the office and get the advice on when that will be provided. In regards to the motion to continue the findings, are we going to wait on that as well?
That goes back to the question, what finding of incompetence?
He was found incompetent
In
this case in 2019.
Yeah, no, I'm not. I'm totally disregarding that because the circuit court is exploring the issue of competency in a fresh way. And of course, as you know, the question before the court is not. The question before the court is whether he is today incompetent to stand trial, not whether he was 2019. I understand there is a presumption of incompetence until such time as the finding changes, but I'm not going to make an affirmative finding of incompetency. I'm going to rely on Judge Young's determination after he's had an opportunity to review more recent evaluations. As you know, these things are fluid sometimes, and sometimes not. But so I'll deny the motion to continue a finding of incompetency that's rooted in a finding in 2019, and we'll track the findings of Judge Young.
Okay, thank you, Your Honor.
All right, just
On that new case that you guys are talking about, it's right now set for pre-trial. Are we gonna keep it or just cancel it and then just?
cancel it.
Okay.
Yeah, we're canceling a pretrial because competency is still an open question. So we're going to cancel the pretrial in case number 21MM59. And it'll be in the same camp as these. We'll set it.
What was that status date for the competency status date?
Hold on 1 second. It's April the 9th. I just need to check the time.
Okay. April 9th. Hey, that's just 2 days later, right?
Do you want it further? We could do
Yeah.
April 16th. That's our problem.
I would say about a week afterwards. So that would be the 14th, but who knows what day that is. Yeah, let's just, as soon as after that. You said the 16th?
The 16th, which is Friday.
That's fine.
Okay. April 16th at 10 o'clock.
Okay, April 16th at 10 a.m. Again, Ms. Reed, I very openly invite you to submit that conditional release order, and I'll review it and take care of it. Thank you.
Your Honor, I do see Mr.
Okay, since Mr. Card's here, I know I announced a recess a minute ago, but we're going to go ahead and deal with the Richard Brown matter. Mr. Campbell, did you listen to everything that was said? He's muted. Did you listen to everything that was said?
Yes.
Okay, your attorney's working hard on your behalf. Thank you, sir. I want to call up Mr. Richard Brown now. Let's see what date it was. That was number 53. Okay, this is 2020 MM 2929, State of Florida versus Richard Brown. Mr. Card is counsel of record for the state, and he's here today. Mr. Card, it was announced they wanted to plead to the bench. Anything before we go forward that I'll turn to you for a factual basis and sentencing recommendation and even possibly a sentencing deferral. But since you weren't here when we started the arraignment, anything before we move forward?
I would just say that I was able to make contact with the victim in this case this morning. She did tell me that she didn't want to be present for sentencing.
Okay. Did you get that, Ms. Reed?
Yes, I did.
And you fill out a plea form with your client?
Yes, I did.
Mr. Brown,
Yes, sir.
this is 20 MM 2929, violation of a domestic violence injunction by communicating or contacting. If you wish to move forward with the plea, please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Now, Mr. Brown, did you sign the plea form in this case?
Yes, sir. Yes, sir.
Before signing it, did you read and understand it?
Yes, sir.
Did you have a good chance to talk to your lawyer about this decision?
Yes, sir.
If you're not a United States citizen, do you understand this plea will subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone made any promises or threats to coerce you into entering this plea?
No, sir.
Do you understand the maximum sentence is 1 year in jail and a $1,000 fine?
Yes, sir.
Has anyone made any promises to you as to what your specific sentence in this case would be?
No, sir.
Understanding these rights and consequences, do you wish to give up your right to a jury trial and enter a plea of no contest to violation of a domestic violence injunction?
Yes, sir.
I find the defendant's alert and intelligent, understands the nature and consequences of this decision, and that this plea is freely and voluntarily entered into before finalizing acceptance. Mr. Carr, do you have a factual basis?
Yes, Your Honor. Alex Card for the state. In this case, the state would show that on December 4th of 2020, the victim in this case, Ms. Kelly Brown, informed law enforcement officers that she was leaving work when she saw her ex-husband, Mr. Brown, outside of her office building by the parking lot area. She walked to her car and saw Mr. Brown, who was also walking towards her vehicle. She then got into the driver's seat of the vehicle and attempted to shut the door, but Mr. Brown arrived at the car in time to keep the door open. The victim noticed that Mr. Brown had a bag with him at the time. The victim told officers and later saw for herself that in the bag was a loose piece of concrete. It was roughly the size and shape of a brick. Law enforcement found this bag and also saw the brick for themselves inside of the bag, which was also filmed on their body cam videos. The victim later informed law enforcement the defendant threatened to use the brick to damage her car if she tried to leave. And while in her car, the victim texted a friend to call 911. Law enforcement were notified by the friend's 911 call and responded to the scene where they made contact with Mr. Brown and Miss Brown. Post Miranda, the defendant, Mr. Brown, stated that he was walking in the parking lot and the victim asked him if he was okay. The defendant stated he told the victim he was having a bad day and he walked to her car where they sat until law enforcement arrived. The defendant denied there was an injunction in place and stated that he and the victim are still together. Law enforcement at the scene were able to confirm there is an injunction. It was 18 DR 5283, a domestic violence injunction, and that this was served on Mr. Brown on January 9th of 2019 and expires on January 3rd of 2024. The injunction stated the defendant should have no contact with the victim, Kelly Brown, whatsoever, to stay away from her home, property, school, place of employment, and not to communicate with her or her coworkers or family. At the scene, law enforcement officers were able to confirm the defendant's identity as Mr. Richard Brown, the defendant in this case, and all events did occur in Osceola County, Florida.
Okay, just a moment. Let's see, image 10. I'm just looking in 18 DR 4347, or actually I wanted to see. Did you say 5283? 18 DR 5283?
Yes, Your Honor. 18 DR 5283 DV.
Okay. Okay. Let's see. Let's see. Let's look at image 12. Yeah, okay. Then maybe 14. And just go to the last page. Okay. Just a second. All right, in addition to the recital of facts from the state, is the defense willing to stipulate to a factual basis?
factual basis for
All right.
purposes of the plea.
Okay, then, Mr. Brown. I was looking for. Sometimes at the end they signed it.
Yeah, it
Let's see.
should be in the back.
Okay, Mr. Brown, I do accept your plea of no contest to violation of domestic violence injunction by communicating or contacting. Before proceeding to sentencing, both sides have a right to be heard. I'll turn to the state, Mr. Card. I'm interested in any criminal history and then any other thing you might have to share.
Yes, Your Honor. The state would put the criminal history on the record. In 2007, there is a conviction for aggravated battery with great bodily harm. In 2015, there's a conviction for fleeing and attempting to elude. In 2016, there's a conviction for no valid driver's license. In 2018, there's a conviction for possession of cocaine. 2019, a conviction for possession of firearm by a convicted felon. 2019, there was a conviction for robbery, sudden snatching. And then there was this charge of violating an injunction, which is the 20 mm 2929 charge. After this charge, while on release, there have been new charges that were recently filed on by the state. That was possession of drug paraphernalia, resisting an officer without violence, burglary of a dwelling, criminal mischief, an aggravated fleeing and attempting to elude with a no valid driver's license and reckless driving, a carjacking with a weapon or firearm, robbery with a firearm, possession of a weapon by a convicted felon, and an aggravated assault with a deadly weapon with leaving the scene of an accident.
Did the defendant, well, that's okay. What were you going to say?
Well, that was the entirety of the criminal history.
Right, and you had also indicated that the victim chose not to be here for sentencing.
Yes, that's correct.
Any input?
Yes, Your Honor. I have spoken with the victim about the case. She did express to me that this incident was very traumatic for her, and she was in a great deal of fear, especially considering that the one thing that was brought to her place of work was the bag with the brick in it. So she was concerned about some potential violence, although she did say that it seemed to be implied that this brick would be used for the vehicle and not for any attack on her person.
All right, Ms. Reed.
Yes, defense would like to put on the record that Mr. Brown has already been in this case for 52 days, so is asking the court to take that into consideration. Defense also spoke to the alleged victim yesterday. She called my office and just expressed her desire, just wanting to help with the case and help Mr. Brown in any way that she could. I did explain the charge and the nature of the charge without getting into details, and then she did ask me if she can fill out a declaration of prosecution. I explained to her that while that can be done, it is not going to completely dispose of the case because it's a different situation, and she understood that, and that was my conversation with her. The defendant, while he is here for other serious crimes, he is willing to take responsibility for this one, and he wants to resolve this one today so that he can put his energy on focusing and finishing the other charges that he is in custody for. So we're just asking for the court's consideration on those facts.
All right. Mr. Brown, anything before sentencing?
No, sir.
All right. All right, Mr. Brown, the court having considered the underlying facts upon which the charge is predicated, considering any aggravating circumstances, notably the substantial criminal history, including violent felony priors, and also taking into account that you're taking responsibility for the case today by entering your plea of no contest. I will adjudicate you guilty of violating a domestic violence injunction, sentenced to 180 days in the Osceola County Jail with credit for the 52 days that you've already served. There are mandatory court costs of $273, a $100 cost for the services of the Public Defender's Office, a domestic violence surcharge of $201, which brings the total to $574. I'll simply order that you report to the Clerk of Courts Collections Department within 5 days of your release from custody, whenever that might be. I know it won't be for a while, but don't forget to report within 5 days to make a monthly payment plan for this obligation. In addition to your sentence, you're to have no contact whatsoever with Ms. Kelly Brown. You obviously are not to possess any weapons or firearms. You can't do that anyway, as you know, or any ammunition. No contact means no communications whatsoever, directly or indirectly, of course. You have 30 days to appeal the judgment and sentence of the court, and you'll remain in custody to serve the balance of the sentence. All right. Good luck. Thank you. Thank you. All right, Mr. Card, did you have any other matters?
Nothing further, Your Honor.
All right.
Other cases where the people are in jail and over promotions.
Okay.
Both of them are.
Yeah, I know. I'm going to come back to it. I'm going to take a brief recess, as I said before. So we'll be in a brief recess. We'll reconvene in about 15 minutes. All right, thank you.
This court
Everyone, Judge Epperson. I want to call up a couple of cases. If someone's at the jail there, can you hear me? We still had a couple of matters to deal with. They did.
Are there still people in jail?
I had Mr. Burton.
Burton has COVID.
Oh, okay.
Burton has COVID. They let us know. I was in there earlier with them.
Okay. Well, I do want to call the case up if you're able to take care of it. It's 21 CT 245, State of Florida versus Burton. Let's see, drew a blank on that. All right, so 21 CT 245, 21 CT 246. It's a Dwillis and a no registration charge. The defendant's been in custody 29 days, apparently has COVID or...
Yes, Your Honor. The COs in there informed us that he is COVID positive, so he was not able to be brought in.
Okay. Well, it was a motion was filed on the grounds of competency, motion to continue a finding of incompetency, and I did review the evaluation of Dr. Danziger. Both parties wish to be heard. It was your motion, so it was the defense motion. Mr. Usich?
Your Honor, I believe this was Jure Reed's. I haven't had the ability to look at the motion as of right now, so at this point I would just be able to stipulate to the court.
Yes, Judge. Just due to the severity of the case in this case, the state would have no objection to the continuing of the finding of incompetence from the prior case. With that being said, I mean, if we could just set this for a status date.
Okay. The problem is Dr. Danziger opined that he believed the defendant could be restored to competency if the defendant would take part in a competency restoration program at Aspire. My inclination was to release the defendant on certain conditions, and I need to tell him those conditions.
If his presence is required, we'll be able to reset this.
Yeah. Let me just take a look at his driving record just a second. Ooh. Got 6 priors.
That case that, was referenced here, is
Yeah.
the Orange County case is set for, pretrial on March 16th.
It is set for pretrial?
It is. I'm just looking at it now.
Okay, because Dr. Danziger's evaluation was in January of this year, I believe.
This is the case.
Yeah, let's see, they must have dealt with competency, let's see.
I was trying to scroll through here to see if I'd seen something. Did you see it quicker than I did?
Yeah, okay, hang on. Let's go closer to the top, the newer, the most,
Okay.
the newest.
The newest one is, I'm sorry.
Yeah,
Order setting.
okay.
You want to check these minutes?
I know,
Oh, sorry.
that's all right. Let me just keep scrolling down here. Here for evaluation. It's stale, current reports. That's odd. Maybe they just put it on pretrial to keep it tracked because it appears that there was an entry in October where the court indicated there was issues of competency that needed to be resolved, and even mentions Dr. Danziger reevaluated on 10/28. We've got in our court file. Just a minute. Okay, so I have in my possession here, my actual possession, an evaluation by Dr. Danziger. It was done for 18 CF 7864, which that's the Orange County case, in which he finds the defendant incompetent, and again, like I said, recommends aspire. So here's the bottom line. I'm finding the defendant incompetent to proceed based upon Dr. Danziger's recent evaluation. Are you willing to waive your client's appearance?
Yes, Your Honor, we'll waive his appearance and ask for him to be released, considering the finding of incompetence.
Any objection, State?
No, Your Honor.
I'm placing the defendant on conditional release. The defendant must report to Aspire Mental Health. It's a nonprofit mental health treatment facility called Aspire. He must report there within 48 hours of his release and must participate in all mental health treatment, including taking any prescribed medications and participating in any therapies. And attending any appointments. Yeah,
I'm sorry, I know you said 48 hours.
of release from custody.
If he has COVID, do you think that is that right?
Within 48 hours of release from custody, yeah. I'm sure the facility will have its own protocols for that, it should, in terms of evaluating whether they can enter. Okay, so that's the order on, and that's for both 21 CT 245, 21 CT 246. We're going to set these for competency status evaluations in late August, anytime around August 25th or as soon thereafter. I know there's no one there, so, but there was another, Scotty Coburn at 11 was an inmate.
Judge, can we set it for August 27th?
Yep. Yes, I mean. Okay, we had Scotty Coburn also at 11 a.m. and he was an inmate.
Scotty Coburn, it was a motion hearing?
It's a competency issue and he's an inmate.
Yes, he wasn't present as well, so he must have been in the same pod with the COVID. I did speak to APD Antonian. She did advise me that this would be, we would be requesting to adopt a CF finding of incompetency from the felony case and incorporate it into this case as well. I believe the motion has already been filed.
Oh, 21 MM 282, Scotty Coburn. State wish to be heard?
One moment, Your Honor.
I believe this is the case where Judge Wilson very recently made an incompetency determination as recently as February 12th, 2021.
Yes.
So I don't know if parties have had benefit of that. It's in the court file. It was attached to the motion filed by defense counsel.
And Judge, what was the case number for the felony where the adjudication of incompetency was filed?
Yes, it was 2018 CF 1379. That's 2018 CF 1379. Notwithstanding the date in 2018, the incompetency finding was just a week or so ago, or let's see, yeah, by Judge Wilson. So
No objection, Your Honor, to incorporating that finding.
I'm going to adopt the finding of incompetency since it's fresh. Find the defendant incompetent. I'm going to place the defendant will be released on this case today, conditional release. I'm ordering that the defendant report to Park Place within 48 hours for a mental health evaluation, that the defendant take any prescribed medications and participate in any therapies, and attend all doctor's appointments for mental health treatment. And we're going to set the case out for a status hearing approximately 6 months, and we'll utilize the same date we utilized in the last case, being,
August the 27th at 10 o'clock.
okay, and he's found incompetent. And just so it's clear, Mr. Usage, you've waived his appearance at the hearing?
Yes, Your Honor.
Okay, very good. So we don't need the TV. Yeah.
Are we still gonna track this, felony case?
Yeah, let's put that in the note that we're tracking case 2018 CF 1379. Thank you, Madam Clerk. We're tracking that case, so we won't be duplicating any efforts at evaluations. Let me call up the Michael Ford case. Michael Ford, which is case 20 MM 1946.
Yes, Your Honor. Add your usage for the defense.
All right, Mr. Ford, your date of birth? The docket says that your date of birth is September 18th, 1990. Is that true?
Yes, sir.
Okay. Mr. Usage?
Yes, Your Honor. The report by Dr. Dornsville was completed and provided to state as well. He was found to be incompetent once again in this case. At this point, we would ask the court if it will consider dismissing this matter. However, there is an accompanying felony case as well, and there is another evaluation scheduled for March 2nd on that case. I just wanted to make that aware to the court. But we would ask for the dismissal of this misdemeanor case.
Okay. State's position?
Your Honor, in light of the additional felony case 20 CF 2276 for the record and the additional evaluation that was ordered, we would just be requesting to track the open felony case.
Okay. Let me look at 20 CF 2276. I think there was a recent finding of incompetency. Let's see. Or they had one evaluation and they wanted another one. Let's see. I have an evaluation that's very fresh, February 21st, Dorsonville, that you referenced, and she found him incompetent.
Yes, Your Honor.
Can we go back? Did we not stipulate to one evaluation in this case?
Yes, Your Honor.
Yeah, we can see the worksheet in our case. Let's see. You said yes. What did you base that on, Mr. Usage?
On this case, we stipulated to one evaluation.
I thought we did.
That's what I was under the impression, State?
Yes, Your Honor.
Yeah. Okay, now let's go back to the CF and see what the posture is. It's set for status hearing on April 7th. Okay. I'm content. I'm gonna. It's kind of a hybrid here. I'm going to find the defendant incompetent. Both parties stipulated to rely upon one evaluation. So I'm going to find the defendant incompetent based on Dr. Dorsonville's. Obviously, that would be subject to change in the event there's a contrary circuit order entered. I am going to track rather than dismissing the case, unless the state has no objection. Any objection to a dismissal?
Yes, Your Honor, we would ask that the court track the open felony case.
Right, well,
Your Honor, if I may be heard, there were previous competencies completed by Dr. Dersenvik that found him permanently incompetent due to a mental health, intellectual disability. If the court would take that into consideration in dismissing this case, and due to the fact that the reason why by Dr. Dornsville is so fresh, also finding him incompetent, that's why we would ask for this case to be dismissed here today.
okay, I saw those. I also looked at the underlying facts of this case. It looked like it was a brief tensing up in terms of the predicate for the resisting while the defendant was in a motel room or something, but under the statute, the state's entitled to a 6-month recheck. I don't know, unless the state has any reconsideration of that.
Your Honor?
Mr. Usich was pointing out some additional factors in support of his request for the court to dismiss the case. I didn't know if that caused you any reconsiderations or not in terms of any objections to a dismissal.
He had previously been found permanently incompetent due to intellectual disability on 2 other previous evaluations that were conducted.
Your Honor, my only concern is that if this would have any bearing on the evaluation that's being done in the circuit felony case. So that's just my only concern at this point in time.
Okay, the court will track case 20 CF 2276. We'll set this for a status hearing approximately 1 week after April the 7th. That would be, that's fine, yeah, April the 16th will be the next court date. But again, I have a finding of incompetency in this case, and we'll readdress the matter at that time and track. Okay?
Yes, Your Honor.
All right.
Thank you, Your Honor.
Thank you, sir. We'll give you your paperwork in a moment. Yep.
Stipulation to one evaluation. Can I put it on this one?
Yeah, parties stipulated to one evaluation. Yeah, yeah. Let's see. Yeah, Ms. Reed, I believe you were counsel of record for Burton.
Yes.
I entered an order releasing him, conditional release. Mr. Usich stood in for you. I hope that was okay.
Yes,
if not, go hit him or something. Yeah, he very capably represented Mr. Burton in asking for a conditional release. And that's what we did. I ordered him to report pursuant to, I think it was Dr. Danziger's order, to aspire within 48 hours of release to avail himself of treatment.
Okay, thank you, Your Honor.
All right, thanks. Let's see. Christina Gonzalez. Said,
I just got off the phone with her. She's taking a bus here. This will be a plea today. It's a credit time served offer. I have the plea form completed already. I'm just waiting for her to come here.
okay, I'll call it up when we've finished all the others, and hopefully she'll be here. Thank you. Joshua Board, set for an arraignment at 10:30. Is Mr. Board present? Can we just, in an abundance of caution, call the halls for Joshua Board? Joshua Board. I see some mingling around out there, so.
The notice he sent out went to this Conway address. He did, or someone purporting to be him, changed his address.
Okay.
So my assumption is that when somebody told him he had
No matters right now.
Okay, thank you, Deputy. State and, actually, it's not represented yet by PD, but there is some reason to believe the defendant may have not received notice. There was a change of address that was provided, so I'll forego the issuance of a warrant and simply reset the defendant for an arraignment a couple of weeks out, no sooner than 2 weeks out, and we'll renotice the defendant at the address provided. It's 20 CT 2328. Yep.
March 19th at 8:30.
All right. Is Glenn Cabral here? Glenn Cabral. Okay, I did permit a virtual appearance because of the unique circumstances that are involved in one matter here. See if...
Your Honor, I believe I was sent the virtual link or invitation to that, so I think Mr. Lentz is going to need the link.
Just make sure that the other attorney is with us here. Yes, he was invited, so let's see if he's here. The defendant was noticed to be here. I'm sure he probably was, but.
Doesn't show that. Under notice of warrant, it does not show.
Case set for county version rejection. Let's see, image 66. Case set for 3-8.
This is a CP evasion. Oh, okay, yeah. Okay, yeah, not at this time. Yeah.
Slow. Mr. Barzokas? Okay, I think we're on board now. Mr. Barzokas, if you can speak, so.
Yes, sir. Can you hear me?
I can hear you clearly. And let's see, our assistant, who's handling this for the state? You say Mr. Lentz is handling it?
Yes, Your Honor.
Okay, so he should be, he's about to jump in right now. Mr. Lentz, can you hear me? There he is. All right, hey, Mr. Lentz. All right, the state typically doesn't really have a dog in this fight, and I typically just sign these in chambers. But when I looked it over, I wanted to give the defendant an opportunity to be heard. Sometimes these motions will put in the body of the motion the fact that the defendant has no objection and blah, blah, blah. I didn't see any of that. Before we went online, I asked Madam Clerk here in the courtroom whether the defendant was noticed for this hearing, and the defendant was not noticed. He is set for a county diversion rejection hearing, I believe on March the 8th, coming up. Mr. Barzokas, can you add a little bit to the motion as to the basis for the withdrawal?
Yes, Judge, we did notice Mr. Cabral. He doesn't know about the hearing. My understanding was he was supposed to be appearing virtually. So our office did tell him to have a certified letter.
Oh, okay, because he didn't receive a link. We didn't have his email. I'm happy to invite him in if you have a means of reaching him.
Yes, Judge, I believe we sent it, at least what my staff member told me.
Okay. Well, let me ask.
Certified mail, I see the green here. It looks like it was delivered on, February 13th, 2021.
Okay.
Signed by Mr. Cabral. So.
Do you happen to
File, Judge.
do you happen to know his position on the motion?
Judge, I haven't spoken to him personally about his position. I mean, I'm elaborate, don't want to cross the range of attorney-client privilege. It's really just a financial, Judge.
Okay.
So, I mean, I don't know if you want me to get more or if the court, like I said, I don't want to do anything improper.
Well, the reason I didn't think he was here is because I'm relying on the notice of hearing that's in the court file, and the notice of hearing doesn't indicate that he was served. That's why I thought that he might not be aware of the hearing today. But based upon what you've said, he was noticed for hearing. Now, you said you sent him a link for the hearing?
Judge, may I have, I thought he was going to be virtually with us. May I just call my downstairs?
Sure.
For 1 second. Judge, I have my staff member coming up right now. She did send me the link and I believe spoke to him. I just obviously don't want to make any misrepresentations since I didn't personally speak with him. So she may be able to shed some light, but I do have this the certified letter that looks like he signed it on the 13th of this month.
I know I wouldn't qualify as an expert on the workings of Teams meetings, and I wasn't sure if the fact that we did not send him a link as the host, whether that would be an impediment to his ability to enter the lobby. Probably not.
So, yes, sorry, Judge Jefferson, can you just will you let him know that you sent the link, Mr. Cabral? This is my staff member, Janice.
Hello, Janice.
I sent him a link with high priority and I did the residency option, and then we called it right after the hearing and when it was recorded.
Okay. And when you say you sent them the link, how did that work? How did you do that?
I forwarded the link that was provided from the court.
Okay. All right. I appreciate you coming over and talking to us. Thanks.
Thank you.
Is it fair to say what you said earlier, from what you said earlier, then that he's not been paying for the services pursuant to your agreement?
Yes, Judge. I think the only full payment he made, other than a couple of partials, was about a year ago, in April of 2020. We tried to stay on to resolve his case, but at this point in time, it's going to end up being a trial. It's just become a hardship for us, Judge. He's not even close.
Okay. State, I assume you have no position in this matter?
No, Your Honor.
All right, it is 10:50. Sounds like the link was forwarded to him in a manner that he could access, so I'll go ahead and grant the motion to withdraw, and all further pleadings and papers shall be served upon the defendant Glenn Cabral at the last known address, which is 7547 Sugar Bend Drive, Orlando, Florida 32819. And the office of Ali and Blankner is withdrawn. All right, thank you, Mr. Barzokas. One moment, Madam Clerk. Okay, thank you. You're excused. Appreciate it.
Thanks for your time.
Okay, we'll leave the meeting.
Can we just kind of get the record on Mr. Scotty Colburn? I know we're tracking what was stated as 18 CF 1379, which was what the motion stated, but it's not 18 CF 1379. It's supposed to be 20 CF 1379.
Okay, public defender Scrivener's error.
Yeah.
Okay.
I just wanted to.
That's fine. We'll correct it. We all have Scrivener's errors.
We are, for sure.
I signed this, but you're doing electronic, right?
Yeah.
I don't believe so, no. You don't have anything virtual, do you?
No.
Okay.
I don't know. I was just reading it.
Who's that?
On the Coburn. I was reading the, submitted to the, Department of Children and Families.
Okay.
That's fine.
Yeah. Okay, let's move on through our docket. Let me call up the David Crawford case set for an arraignment. David Crawford, last call, 21 CT 167. David Crawford. Seeing no response, no one in the hall?
Yes, Your Honor, Yvonne Antonian on behalf of the defense. No information.
Okay, we have no response and no info, so given the cumulative effect of that, the court will revoke pretrial release, set bond at $1,000 for failure to appear, waiver of speedy trial in 21 CT 167. Tremaine Flats, case 26.
All
right, 16 MM 3080. You can come on up, Mr. Flats, along with the application. This was docketed for, I think, about 22 minutes ago, so should be about done with
Your Honor,
that.
just as a friend of the court, we were talking to the defendant and explaining to him what was happening, which delayed in him filling out his application. So if it's possible, if we can recall this. I was just also speaking to the state attorney to see if there was a possible resolution for today.
All right, Mr. Flats, how far are you on your application there?
Halfway done, sir.
Halfway done? I'll recall you in a minute. Thanks. Ramon Garcia, 20 CT 3383.
Your Honor, just under the court, he did complete an application for probation.
Mr. Garcia, good morning.
Good morning.
Your date of birth?
Say that again?
Your date of birth?
11/24/95.
Okay. Now, this says you have 4 dependents. Is that true?
Yeah.
Okay. Based on your application, I will appoint the public defender to represent you in this case, so you now have legal counsel. You received a citation for operating a motor vehicle without having a valid Florida driver's license. That's a second-degree misdemeanor. It looks like this resulted in some type of crash. You have the right to remain silent today. Just one moment. I'll give you a chance to speak if you and your lawyer wish to. All right? The maximum sentence is 60 days in jail and a $500 fine. You're presumed innocent of the charge. You have the right to a lawyer. And if you don't have enough money to hire one, I can appoint one, and I just did. So you now have an attorney. You have the right to remain silent today because anything you say today could be used against you in the future by the state. The main purpose of this hearing is to tell the court whether you wish to plead guilty or not guilty. Now, I said that you have the right to remain silent. The only exception to that is if I ask questions about your identification, such as your date of birth and your address. We need to make sure that we have the proper address when we send you notice. Obviously, you're here today, so you got notice, but just to be clear, where should we mail your notices if we do?
I don't have an address at the moment. I've been going back and forth between New York and Florida because my daughter's in the hospital.
Okay, well, we definitely need to be able to send you notices, so we need the best address possible. Just a moment. Small handwriting. Is that 1658 Providence in Brandon?
And 1085 Brandon.
1085?
Yeah, I'm sorry.
Okay, is it 1085 Providence?
Yes.
That's Providence Road?
Yes.
Okay. And what's the zip code?
I do not know. That's where one of my friends is staying.
All right. The reason I'm stressing this is because if you don't show up for a hearing, then a warrant gets issued.
Yeah.
Then you get picked up. So you have a responsibility just to make sure that the clerk has your current address. All right. Now, let me turn to your lawyer. Mr. Usich, do you know how your client wishes to plead today?
Yes, Your Honor. We enter a plea of not guilty.
Okay. A not guilty plea is entered today on your behalf, and your case is going to be set for pretrial conference on the following date and time.
Pretrial set for April 21st at 9:30.
Okay, so that's the next court date. Now, let me just make a brief inquiry of both parties here. Since the defendant is here, was an offer conveyed, or?
Not at this time, Your Honor.
No offer?
No, Your Honor, this is a crash case and we're waiting on additional facts.
Okay, fair enough. Mr. Garcia, we'll give you your paperwork in just a few minutes. Make sure that you stay in touch with your lawyer. That's very important, and he'll probably want to have an appointment with you. All right, thanks.
Thank you.
Luis Guzman Negron. Luis Guzman Negron, 20 CT 3218. Not present.
Possibly, yeah. Possibly. Let me just double check. Tiana speaking with a Spanish individual.
Okay. Thanks.
Your Honor, as a friend of the court, he is going to need the services of the interpreter.
Okay, he can come on up. Did he fill out an application for the public defender?
No, Your Honor, not yet.
Not yet. Do you think he's going to?
Not sure, Your Honor. We were in the middle of discussion and we didn't reach a conclusion.
All right.
Good morning, Your Honor. For the record, Jose Sendra, certified Spanish interpreter, previously sworn in and ready to proceed.
All right. Good morning. We're in courtroom 5B, as you know. This is case 20 CT 3218, State of Florida versus Luis Guzman Negron, who is wearing the headset. If we can confirm connection.
Sí. Okay.
Your Honor, we have a connection.
Okay. Mr. Guzman Negron, good morning. I'm Judge Epperson. Can you please tell me your date of birth?
Cero dos del 89. Febrero 12 del 1989.
12th of February, 1989.
You've been accused of operating a motor vehicle without having a valid Florida driver's license. Offense date December 2nd, 2020. Under Florida law, this is a second-degree misdemeanor with a maximum punishment of 60 days in jail and a $500 fine. You're presumed innocent. You have the right to a jury trial, where the state would have to prove guilt beyond all reasonable doubt to a unanimous jury. You have the right to a lawyer, and if you don't have enough money to hire your own attorney, I can appoint the public defender to represent you. It's almost always wise to have a lawyer when you're accused of a criminal offense. If you wanted to have a lawyer, do you believe you have enough money to do so, to hire a private attorney?
Me quedaría con uno público, no estoy para gastar dinero en un abogado porque me quedé sin trabajo hace prácticamente 3 semanas. Tuve que entregar mi apartamento.
Let me see. I would like a public defender because I am struggling economically. I was left without a job, and 3 weeks ago I had to go leave my apartment.
Okay. Then you need to complete an application for the public defender's office, and then I'm going to recall your case in just a few minutes. All right? Make sure that you answer every question. Where there's a yes or a no, you'll circle either one, whichever is applicable. And then you'll fill in an amount if the answer is yes. So you can take off the headset and fill out the application. I'll recall your case shortly.
Gracias.
Thank you.
Are there any further interpreter needs that we're aware of? Any others? No? Okay, thank you, Mr. Sendra. We're going to go ahead and excuse you.
My pleasure, Your Honor. I'll be here for the next call.
All right, have a good day.
Thank you, sir.
Sendra. Sendra? Okay, let me go to the Gonzalez matter. I've been given a plea form. Christina Gonzalez. Case 20MM3060.
Yes, Your Honor, Admiral Eustace for the defense.
All right, Ms. Gonzalez, I've been given a plea form, so please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Usich, the anticipated disposition?
Yes, Your Honor, it will be an adjudication of guilt, credit time served, and court costs.
There's 2 counts. Do you mean for each?
It's concurrent on both counts, Your Honor.
All right. Is that the state's understanding?
Yes, Your Honor, my apologies. That was the state's offer.
Okay. 1030. It doesn't say that record. I got it.
Okay.
No, I wasn't asking for one. I just said it. Yeah, I'm sorry. I got it. Let's see. Has the potential 5-year revocation been explained to your client?
Regarding the HTO, Your Honor?
Yes.
Yes, Your Honor, if we can go over it one more time, I can freshen it up. She was just released from Polk County Jail, so we can freshen it up right now.
Well, I don't need you to freshen it up as long as it's been done. Are you sure it's been done?
Your Honor, if we can go over this one more time, I would appreciate that if we can recall this.
This is a 4th Willis, and there's one from June of 2017. There's one from May of 19. Now, both of those, there were 3 points that went on the driving record, so they were likely civil in nature, but that's still, you'll need to discuss that with your.
Yes, Your Honor.
Yeah, I'll come back to that in a moment.
Thank you, Your Honor.
Tremaine Flats, we ready on that? He's outside. Don't worry about it. Let me go on. Roland Ford. Roland Ford.
Good morning, Your Honor.
Good morning, Mr. Ford. Just a second.
Yes, Your Honor, Admiral Eustace for the defense.
Okay, this is a matter that's been set for sentencing. Mr. Ford entered a plea of no contest to driving while license suspended back on February the 10th, and at his request, we deferred sentencing, and he's faithfully appeared, so I'm going to go ahead and proceed. State wish to be heard before sentencing?
No, Your Honor.
Defense wish to be heard?
No, Your Honor.
Okay, 20 CT 1777, Mr. Ford, good morning. Having previously accepted your plea of no contest to driving while license suspended with knowledge, I'll honor the plea agreement adjudicating you guilty and sentencing you to 30 days in the Osceola County Jail with credit for the 2 days that you've already served. There are mandatory court costs of $273 and a $100 cost for the services of the public defender for a grand total of $373. I'll simply order that you report to the Clerk of Courts Collections Department within 5 days of release from custody to make a monthly payment plan for this obligation. That's part of your sentence, so just make sure that you do that. You do have 30 days to appeal the judgment and sentence of the court, and to be clear, that's the judgment is for driving while license suspended with a prior conviction for driving while license suspended. State have any objection to the court dismissing the 2 companion citations?
No objection, Your
Mr.
Honor.
Usich, do you have any request in that regard?
Your Honor, as a friend of the court, we would just ask the 2 companion infractions be dismissed.
Okay, I'll dismiss those 2 citations. That's 20 TR 18546 and 20 TR 18547. Mr. Ford, good luck to you. There'll be a fingerprinting, and then you'll be remanded to serve the balance of your sentence. Thanks.
Thank you, Your Honor.
Jimmy Gonzalez. All right. Well, in 20 CT 3070, Mr. Jimmy Gonzalez entered a plea of no contest on Feb 9, and I agreed to the court agreed to defer sentencing at his request, and he's not present. So the plea is final, but the sentence is to be determined. Court will issue a capias for failure to appear at sentencing, streak the bond, 0 bond. All right. Thanks. Tremaine Flats can come forward. He finished his application. He's out. That's okay. He's out talking. We'll just give him a minute. I don't see anyone else in the courtroom. Well, we have 2 state attorneys and 2 assistant public defenders. So let's go to the never-ending saga of Rodkeem Gardner, 17 MM 2508. Any update, State?
Your Honor, we did get the fingerprint sent out to the Latent department in the sheriff's office. We have not received word back. We've called them multiple times. We haven't received the comparisons from them on the fingerprints.
Okay. What's the state's recommendation? Want to reset?
If Your Honor would entertain a reset.
To know who the defendant is. So, when did they get the last request from you?
They received an email from our office on February 4th and February 16th, and we reached out to them this week via phone, and we've not received word. And our office sent them an additional email this morning, and we've not received anything back, Your Honor.
All right. Can you tell by your screen there who it is you're communicating with over there?
Looks like Aaron Green.
Is that E-R-I-N or A-A-R-O-N?
E-R-I-N, and green like the color.
Okay. No E on the end?
No, Your Honor.
All right. Do you know Aaron Green's position by chance?
I don't have her specific position, Your Honor, just that she's the point of contact for that department.
Tremaine Flats, 2016 MM 3080, 2016 3080. All right, sir, your date of birth?
10/1/1975.
All right, I'm confused about one thing on your application. You checked that you have take-home income monthly. That's the box you checked, but then there's no amount.
Yeah, I actually made a mistake. I didn't read it all the way through, so I just went ahead and put a 0 and zeroed it out.
Okay, do you receive any monthly income?
My wife, I do work.
Okay, you work and
Yes.
you get paid for the work?
Yes.
How much do you get paid?
2,200 a month.
2,200 a month?
Yes, ma'am.
Okay. So why didn't you put that in here?
'Cause I wanted to qualify for public defender. I can't afford to pay for a lawyer right now.
Okay, so you put 0 income so that you would qualify for the public defender out of concern that if you were truthful and disclosed your income, you might not qualify.
Yes, sir.
Do you realize that according to this document, you just committed a criminal offense punishable by 60 days in jail?
Yes, sir.
I mean, what you just told the court is, I lied to the court hoping I would trick you into appointing the public defender even though I might not qualify.
And I do apologize about that. When he explained to me initially about I was going to go a different route, and then he told me, he recommended me that I take the public defender, and I asked him if I should do another application, and he said, no, just cross it out and mark the boxes.
You indicated here that you have 4 dependents. Who are they? 4 dependents?
My 2 sons and her daughter and her son.
Okay. Now, I need to have confidence that the rest of this is truthful, but
I do apologize to the court.
there's no basis to have confidence. So I need to know if you're making $2,200 a month, do you get a paycheck?
Yes, sir.
Does that go into a bank account?
Yes, it does.
Okay. So how much is presently in your bank account?
$386.
Okay. And if you took all of the cash that you had right now and you just put it in one place, how much cash would there be?
About $800.
Okay. Any stocks or bonds?
No, sir.
Do you own any motor vehicles?
I do own a Nissan Rogue.
A Nissan Rogue?
Yes, sir.
Okay. Is it paid off completely?
No, sir.
Okay.
Well, actually, my wife owns it.
Okay. Well, based on the answers you've now given me, you do qualify for the public defender's office.
And once again, I do apologize to the court, Your Honor.
I'm going to appoint the public defender in this case. Ms. Reed is an attorney standing on your behalf today. The case came back to court because it was originally a diversion case, but then apparently there was some allegation of noncompliance, and so we're back on the docket on a possession of cannabis and possession of drug paraphernalia. Ms. Reed?
Yes, defense will be entering a not guilty plea at this time.
Okay, so a not guilty plea will be entered on these charges of possession of cannabis and possession of drug paraphernalia, and we'll set the case for pretrial conference on the following date and time.
Pretrial set for April the 21st at 9:30.
So that's the next court date. Mr. Flats, just make sure you stay in. Make sure you stay in touch with your lawyer. Okay, make an appointment with your lawyer so you're ready for your next court date.
Yes, sir.
All right, thank you. Case note, need to see latest booking report. Okay, going next to the Luis Guzman Negron matter. I need him in the courtroom. That's that third time I called it, I think. We already, Sorry, Deputy.
Your Honor, we are also ready on the Christina Gonzalez matter whenever.
Do I need the interpreter?
Yes, Your Honor, we do anticipate resolving
Okay.
today. We just have not had the time to thoroughly go through a plea form, Your Honor, as the decision was just made.
All right. Mr. Guzman, you have to thoroughly go over the plea form. I thought we'd be ready to go. So just tell him he needs to finish up with his lawyer if you don't mind.
Señor. Pase con su abogada para que ella vaya.
He's gonna take over.
You know what, the staples have all come out, so what I'm gonna do is, you can just staple this last part, and one of these pages is. No, I know. No, I know. It looks like old-time dockets. Actually, I can remember 125. Of course, Rashard Brown's contributed to all that.
I know, I told Brenda, it's just know that there's like 104 votes because of the one. Oh, yeah, he knows.
Yeah, she gave a message saying, freak out. Okay, Mr. Usich, you said that you're ready on Gonzalez, so we'll go back to that matter. Christina Gonzalez. Okay, I believe we already placed Ms. Gonzalez under oath.
Yes, Your Honor.
And we'll go ahead and proceed now. Ms. Gonzalez, I'm holding a plea form in my hand, which appears to have your signature at the bottom of page 1 and page 2, suggesting you wish to plead no contest to providing false identification information to a law enforcement officer while lawfully detained, and count 2, driving while license suspended with knowledge. Did you personally sign the plea form?
Yes, Your Honor.
And for the record, it's 20-3060 is the case number. Before you signed the plea form, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you have a good chance to talk to your lawyer?
Yes, sir.
If you were not a United States citizen, do you understand the plea would subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No.
Has anyone made any promises or threats to coerce you into entering the plea?
No, sir.
If you drive on a suspended license again in the future, do you understand this conviction could be used against you to enhance your punishment?
Yes, sir.
Also, do you understand that if you were to obtain 3 convictions for driving while license suspended within a 5-year period, that the Department of Motor Vehicles may revoke your driving privileges for 5 years?
Yes, sir.
And lastly, do you understand that you're giving up your right to a jury trial by pleading no contest to these charges?
Yes, sir.
Having these understandings, do you wish to plead no contest to providing false identification information to a law enforcement officer and driving while license suspended with knowledge?
Yes, sir.
State have a brief factual basis.
Yes, Your Honor. On December 18th, 2020, at approximately 22:11 hours, law enforcement was patrolling the area of Walnut Street and Bayberry Avenue. The officer observed a silver Toyota bearing Florida tag HLJ-A17. Law enforcement observed the vehicle failed to make a complete stop at the stop sign on Amiens Road and Walnut Street. As law enforcement got behind the vehicle pulled over to the side and the driver got out of the vehicle. Law enforcement pulled behind, turned on the overhead lights, and conducted a traffic stop. The driver immediately addressed law enforcement, and while doing so, she spontaneously uttered, "I do not have a driver's license. I only have a Florida ID card." Law enforcement advised the driver of the name, agency, and reason for the stop. The officer asked the driver of the vehicle for her driver's license and registration. The driver advised that she did not have a license. She advised that her name was Steppia Allen, date of birth August 23rd, 1993. Law enforcement attempted to locate her name in Spillman and David, however, could not locate her. After a while, she advised law enforcement that she was lying about her name and that her name is actually Christina Gonzalez. Law enforcement was able to identify her by photo in Spillman and subsequently ran her name through the Spillman system, and per DHSMV, learned that she had a suspended Florida driver's license. Christina has had her Florida driver's license suspended indefinitely since November 23rd, 2020 due to failure to pay traffic fines. All events occurred in Osceola County, Florida.
Okay, Ms. Gonzalez, I do accept your pleas of no contest with respect to count one, providing false identification to law enforcement. I will adjudicate you guilty and sentence you to 20 days in the Osceola County Jail with credit for the 20 days you've served. Count two, driving while license suspended with knowledge. I accept your plea of no contest, adjudicate you guilty, sentence you to 20 days jail with credit for the 20 days you've served, concurrent with count one. There are mandatory court costs, $273, and a $100 cost for the services of the public defender for a total of $373. All right, that's $373. I'm ordering that you report to the Clerk of Courts Collections Department today for the purpose of making a monthly payment plan for this obligation. Just make sure you go there today, otherwise it would violate your sentence, which could subject you to further sanction. We're going to give you a bright yellow folder to take with you, and they'll be expecting you on the second floor, all right, for the Collections Department. You do have 30 days to appeal, and Ms. Gonzalez, in looking at your driving record, well, with a 5-year revocation that may take place, that could actually obstruct what I was getting ready to tell you. But it just looks like it's a matter of paying off your tickets to get a driver's license, and you could have avoided the 20 days and other repercussions. So hopefully this will be the last driving while license suspended that you come in court for. All right, you have 30 days to appeal. There'll be a fingerprinting, and we'll give you your paperwork in just a few minutes.
Your Honor, as a friend of the court, would the court consider dismissing the two companion infractions, considering the plea here today?
Okay, I did mean to address those. State, you have any position in this matter?
No position, Your Honor.
Is the state aware of any signs of impairment from the defendant? One of these is an open container. I didn't see any, but it was a quick read there.
The state is not aware of any, Your Honor.
All right. What was the open container?
I don't know. The car isn't in my name, so it belongs to someone else.
Okay.
It's probably already in there.
You don't remember what it was, though?
No, sir.
Okay. The court will dismiss 20 TR 51848 and 20 TR 51849 based on your having taken responsibility for the misdemeanor. So the civil citations will be dismissed. All right, thank you.
Thank you, Your Honor.
Okay. Are we ready on Mr. Guzman?
Yes, Your Honor.
Okay, then we'll try again. Mr. Luis Guzman Negron is coming forward, and I am going to summon the interpreter. I'll take it, yeah.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter.
All right. Ms. Arroyo, we have one matter for you. It is case number 2020 CT 3218, State of Florida versus Luis Guzman Negron, and he is wearing the headset, if we can confirm connection.
Yes, Your Honor. Give me 1 second.
Sí.
Connection is established.
All right. I'm appointing the public defender in this matter based on the application that was submitted. So you have legal counsel, Mr. Guzman. I've also been provided with the plea form. So I'll turn to your lawyer, Ms. Caraballo, the anticipated disposition.
Your Honor, at this point, we'd be entering a plea of no contest with the anticipated resolution of a withhold of adjudication, $100 fine, and court cost.
Is that the state's understanding?
It is, Your Honor.
Mr. Guzman, is that your understanding? That you, please raise your right hand to be sworn. Other hand?
Yes.
Right hand?
Disculpa.
I'm sorry.
Okay, sir, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
Yes.
You can put your hand down. Mr. Guzman, I'm holding a plea form in my hand. It's typed in Spanish. It does appear to have your signature at the bottom. Did you personally sign the plea form?
Sí.
Yes.
Before doing so, did you read and understand it?
Correcto.
Correct.
Did you have a good and meaningful opportunity to consult with your lawyer about this decision?
Sí.
Yes.
If you were not a United States citizen, do you understand this plea would subject you to deportation?
Sí.
Yes.
Are you under the influence of any drugs, alcohol, or medication today?
No, no consumo droga.
I don't consume drugs.
Okay, but are you today under the influence of any drugs, alcohol, or medication?
No.
No.
Has anyone made any promises or threats to persuade you to plead today?
No.
No.
And finally, do you understand by pleading no contest, you're giving up your right to a jury trial?
Sí, entiendo.
Yes, I understand.
Understanding these things, do you plead no contest to operating a motor vehicle without a valid driver's license?
Correcto.
Correct.
State have a brief recital of facts using the microphone.
Yes, Your Honor. On December 2nd, 2020, at approximately 13:42 hours, law enforcement was patrolling the area of Michigan Avenue and Ocean Street. This part of Michigan has no positive medians to divide the south and north lanes. While patrolling, law enforcement observed a yellow marked school bus which had red flashing lights and stop signs erected from the side of it, indicating everyone needed to stop. Law enforcement then observed a white Toyota Camry, Florida temporary tag CUZ 4866, traveling in the outside northbound lane and passing the school bus while the stop signs were erected still. Law enforcement got behind the vehicle and conducted a traffic stop and made contact with the driver. Law enforcement introduced himself to the driver, later identified as Luis Angel Guzman Negron. Law enforcement asked Luis for his license, and he provided law enforcement with a Florida ID card. Law enforcement asked Luis if he observed the school bus, and he advised he did not due to him not being from the area. Law enforcement checked David and input Luis' identification card number and located Lewis's file, and it advised he only had an identification number. Lewis was issued a warning for passing the school bus and was issued a citation for driving without a license. All events occurred in Osceola County, Florida.
Mr. Guzman, I do find a sufficient factual basis to accept your plea of no contest. I accept it. I'll follow the plea agreement, withholding adjudication of guilt, imposing a $100 fine plus costs, which comes to $373. There is a $100 cost for the services of the public defender, so the grand total is $473. How soon can you pay $473, sir?
Una semana.
1 week.
Okay, in an abundance of caution, I'm going to give you 30 days within which to pay. As long as it's paid in full within 30 days, the case gets closed out. You also have 30 days to appeal. And it looks like you just need to get a valid driver's license if you wish to drive. If there's some reason you can't, then just don't drive. But Ms. Caraballo, are you going to say something?
Yes, Your Honor, it appears that there was a $250 bond posted. We were wondering if that would, oh, never mind, it was through a bail bond.
Surety bond, yeah.
Yep, I thought it was a
But I'm
cash
glad you
bond.
brought that up, because the record should also reflect, and I don't want to startle the defendant, but because there was an arrest due to a failure to appear, I am sentencing to 1 day in jail. However, that's to give credit for the 1 day already served. There's no additional jail time in the case. So, Mr. Guzman, just get a license if you want to drive, all right? You have 30 days to appeal. Did you understand the sentence?
Sí.
Yes.
Okay. You can take off the headset. We're going to give you your paperwork in just a moment. Good luck.
Gracias.
Thank you.
Thank you. Thank you, Madam Interpreter. I think we're finished with your services. Thanks.
All right, the interpreter will disconnect.
All right. Is Frank George still in your office, Frank George? Do you know? Frank George, Assistant State Attorney, is he still in your office? Do you know?
I don't recognize that name,
I
Your
believe
Honor.
so, Your Honor. I believe that he's in Orange County, though.
Homicide unit?
Homicide unit, yes.
Okay. He got a citation for passing a school bus at that exact same location about 12 years ago. Michigan and Ocean Street. You can tell him I talked about it in court, but that we were off the record. I mean, the exact same location. Of course, he thought he was innocent of the charge, but yes.
Would the court entertain recalling Jamie Gonzalez, 20 CP 3070?
Yes, but I want to correct the record. It wasn't 12 years ago. It was about 18 years ago. Okay? Yes, he can come forward.
We would be asking for you to revoke or recall the warrants. He had traffic problems this morning, and that's why he arrived late at the courthouse this morning.
What was the number on the docket?
103.
Okay.
Second to last.
Yes, Jimmy Gonzalez. Mr. Gonzalez, your date of birth?
10/15/96.
Okay, this is a case that you had previously pled, and we set it for sentencing today. Just one moment. Show up, and I put the documents in my file. Hang on.
I apologize
I
for that.
retrieved them. Okay. You said you were having some trouble this morning? Oh, transportation, what was that?
Yeah, traffic had held me up by a little bit. It was more than I anticipated.
Okay. I'll recall the previously announced capias. Mr. Gonzalez, from the court's perspective, I went ahead and approved this at the time of plea, but I think your attorneys negotiated a pretty favorable disposition here, given the numerous Willis convictions. At some point, the sentence just has to get a little bit stronger to try to convince people to follow the traffic laws and get a license. But having accepted your plea of no contest back on February the 9th of 2021, I will adjudicate you guilty, sentence you to 30 days in the Osceola County Jail with credit for the 1 day you've already served. There are mandatory court costs of $273 and a $100 cost for the services of the public defender for a total of $373. You must report to the Clerk of Court's Collections Department within 5 days of release to make a monthly payment plan for this obligation. That's part of your sentence. So if you don't go, it's kind of like violating probation. You're violating the sentencing order, which could subject you to contempt of court. So just make sure you follow through. You have 30 days to appeal. Good luck, and you'll be remanded today to begin serving sentence.
Thank you, Your Honor.
Thanks. Okay, on the Rod Keene Gardner case, I'm gonna unilaterally reach out to Ms. Green myself if I can access the email address.
Your Honor, yes, the email is erin.green@osceola.org, but her name did change, so it's Erin West.
Okay, so it's Erin dot
Green
uh-huh
at Osceola.org.
Osceola.org.
Yes. But if you reach out to her via telephone, her name will be under Aaron West.
Okay, that'll be an email. All righty. Let's see. The state just needs to sign the plea form. Have we covered our morning docket? Have we covered our morning docket? Okay. Yeah, I'm gonna reset it. I'm gonna reset it out 2 weeks. Just a sec.
March the 12th, Judge.
Okay, March 12th is the reset on Gardner. Okay, as far as this morning's docket, I think we've covered everything, so we're in recess till 3:30.
Thank you, Your Honor.
Thanks. How y'all doing? Good, good, good. Hanging in there. It's very, 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 very fluid. Yes. Moving is a big deal. It's crazy. It's crazy, crazy.
Oh, okay.
Not old man.
No,
Not everything, but all of the.
Okay, we have the same
Now it's just a
pen.
matter of
Yeah, no, my girlfriend.
all the little stuff.
Yeah.
So, but it's going good. Today is her move-in day, so most likely later today is the move-in day. At the latest tomorrow, but we think we're going to do it today. Yeah. Let's see. Motion to recall, notice to appear, probation or dismiss, violation, reinstate. Well, it's okay. Today is the 20. Let's see. 15. So that Friday, last Friday, I took off because it was closing. We're all the way out at Celebration. The Celebration Title Group is where we did the closing. So afterwards, my wife and I go to
Hello at the jail, can you hear and see us? Thank you. The video.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la oficina del defensor público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre, y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
I got criminal histories here, research.
All right, we're back on the record. Are you Mr. Rodriguez Belmaris? I need you to talk nice and loud into the microphone.
Yes, sir.
Thank you. Mr. Rodriguez Belmaris, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, the whole truth.
Sir, I've been handed a document. It's titled Admission of Violation of Probation Form. It looks like this document. It's 2 pages long, has a signature at the end of it over the word defendant that appears to be Edgar Rodriguez. Did you have a chance to review this document?
I have.
The document in 2018 CF 495 indicates that you wish to admit that you violated probation in that case for the reasons alleged by your probation officer. Is that what you wish to do?
Yes, sir.
You have a right to have a hearing. At the hearing, the state of Florida would have to prove to the judge by a preponderance. That means a greater weight of the evidence that you had violated your probation in a material and willful way. At that hearing, your attorney would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have participated in your hearing, had it recorded, appealed any error that occurred in that process. You understand you're giving up all your hearing rights because if I accept this resolution, I'm going to go along with the agreement you're making with the state, and we will not be having a hearing as to this matter. Do you understand that?
I do.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what is written on your admission form?
No.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No.
Do you understand if you are not a United States citizen, entry of this admission would cause you to be deported?
Yes.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this admission could cause you to be involuntarily civilly committed. Do you understand that? Ms. Rosa, is the defense stipulating to a factual basis for acceptance of the admission?
Yes, Your Honor.
Court accepts that stipulation, finds I have a factual basis with which I can accept this admission, find that Mr. Rodriguez Belmaris appears to be alert, intelligent. He's had an opportunity to think about it and discuss it with Ms. Rosa. Are you satisfied with her help?
Yes, I am.
Yeah, she tried awful hard to get you in front of a judge today, so you owe her some thanks. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Court's going to accept your admission that you violated probation 2018 CF 495. You'll be adjudicated guilty of grand theft motor vehicle if you were not previously adjudicated guilty. We're going to sentence you to the Osceola County Jail, and that will be credit for the time that you have already served.
130 days.
Which is 130 days. Your probation is revoked and terminated. Any money that you owed on probation, you still owe. I'm going to give you a period of 12 months to pay off those costs to the clerk of the court collection program. As long as you're making little payments to them, you'll have no problem. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand?
Yes.
You'll have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. Ms. Russell, did I miss anything?
What was that, Your Honor?
Did I miss anything?
No, Your Honor.
Ms. Brown?
Nothing wrong, sir, Your Honor.
Madam Clerk, we good? All right, good luck to you, sir. You should, as to this case, 2018 CF 495, you should be released today.
Thank you. Thank you, Rose.
All right, thank you. Thank you, Judge.
Your Honor, that's all I have before the court. May I be excused?
Of course. Thanks. All right. For those of you that are here for initial appearance, my name is Keith Carson. I'm one of your circuit judges. You've heard the little video on what first appearance is all about. I'm going to be making a determination as to whether there was probable cause for your arrest, which has already happened. We'll talk about conditions of bond, if any, that are reasonable for your return back to your lives while these cases get sorted out. And finally, we'll talk about getting an attorney on board to represent your interests. First case that I have is a interpreter case. That is Mr. Reverend Perez. Hello?
Good afternoon, Your Honor. For the record, Jose Cedro, certified Spanish interpreter, previously sworn and ready to proceed.
Good afternoon, Mr. Senator. We have Mr. Reveron Perez, case number is 21 CT 537. He's at the jail facility. You'll be doing your interpreting over the intercom system.
Yes, sir.
Good afternoon, sir.
Buenas tardes, señor.
Buenas tardes.
Good afternoon.
You are Mr. Reveron Perez, correct?
¿Es usted el señor Reverón Pérez, cierto?
Sí.
Yes.
So, Reverend Perez, you were arrested based on an allegation of driving while license suspended. I have reviewed your charging affidavit, and there is probable cause for your arrest.
Señor Reverón Pérez, usted fue arrestado por conducir sin tener el permiso de conducir suspendido. He revisado el informe policial y el informe acusatorio y veo que hay motivo fundado para su arresto.
In the driving charge, your bond is set in the amount of $500.
La fianza fijada en esta acusación es de $500.
I will appoint the Office of the Public Defender to represent your interests.
Se designa la oficina del defensor público para representarlo legalmente.
I note that you are out on bond on a felony allegation in 20 CF 1392.
Veo que usted está en libertad bajo fianza en el caso 20 CF 1392.
State, are you requesting the court take any action as to that case?
Fiscalía, ¿qué desea que este tribunal haga?
No, Your Honor. I saw in the clerk's site that there's a plea date set up on March 3rd.
No, su señoría. He visto en el expediente, en el sumario de la Secretaría que hay una fecha ya para el día 3 de marzo de declaración.
Based on this being a lower level traffic offense, the court is going to take no action in 2020 CF 1392 pursuant to the recommendation from the state.
Dado que esto es una infracción de menor calado, este tribunal no va a tomar ninguna acción con respecto al caso 20 CF 1392.
Do you understand that you need to be in front of Judge Young on Wednesday, March 3rd? You're set on his docket.
Usted entiende, señor, que tiene que estar delante del juez Young el día 3 de marzo, que está usted fijado para esa fecha de comparecer en el tribunal.
Sí.
Yes.
That will conclude our hearing. Thank you.
Y con esto finalizamos. Se levanta la sesión.
Una pregunta.
I have a question.
Yes, sir.
Sí, señor.
Me va a dar otro bond para yo poder fiarme de esto.
So, am I going to have another bond to be able to post it?
I granted you a bond of $500 on the driving charge. You're still out on bond on the other case.
Señor, se ha fijado una fianza de $500 sobre la acusación de manejar con la licencia suspendida. La fianza de la otra causa sigue vigente también.
No me puedo fiar entonces.
Your Honor, I can explain it to him further.
Yo no entiendo.
I've appointed the Office of the Public Defender, and she's going to explain stuff to you.
Señor, se ha designado un defensor público, un abogado, y ella se lo explicará todo a usted. Thank you, Your Honor.
Mr. Interpreter, would you mind making an announcement to our group of folks at the jail facility? Did you disconnect?
I can ask, Your Honor.
All right. Thank you, Mr. Nadal.
Your Honor, it appears no one else needs an interpreter this afternoon.
Thank you for that assistance. April Hawkins. Good afternoon, Ms. Hawkins.
Good afternoon, Your Honor.
Ms. Hawkins, you were arrested on an out-of-county warrant out of Polk County. The case number is 2017-5398. Looks like a possession of a controlled substance, violation of probation allegation. Unfortunately, Polk County has granted no bond. You're going to remain on no bond with us. We'll let Polk County know you're here with us, and to make sure we don't lose track of you, we'll provisionally appoint the Office of the Public Defender to keep an eye on you while you're here with us. Thanks.
Thank you, Your Honor.
Jeremy Baker. Good afternoon, Mr. Baker.
Good afternoon, sir.
Mr. Baker, you're in a similar circumstance. You have an out-of-county warrant out of Brevard County in 2021 CF 10210. That has 2 counts. Count 1 is a no bond. You're going to remain on no bond on that case. Count 2 does have a bond or bonds in the amount of $72,000. Give me just
1 second.
Yeah, give me just a sec to take a look at this. I think no bond determination is incorrect. Pursuant to the warrant, there is a total bond in the entirety of the case in the amount of $72,000. I'll appoint the Office of the Public Defender to represent your interests while you're here with us, and we'll let Brevard County know that you are here with us. Yes?
I'm sorry to interrupt, but Mr. Baker would like me to notify the court that the reason that he FTA'd was because he was already in custody here in Osceola.
Okay.
Yes, sir. February 11th, I was supposed to have a court date, and I was incarcerated since, I've been here incarcerated since January 20th. So that's the reason why the Brevard County put a warrant out for my arrest. It's because I wasn't present there February 11th for that court date, and I was incarcerated here. They ROR'd me on my charges yesterday for Osceola County here, and they gave me the warrant last night, or yesterday, and then I did my fingerprints last night. So I don't understand why I would have an FTA if I was incarcerated here and they can't see it through the system.
I hear what you're saying, and it sounds reasonable to me, but this isn't my warrant, and I don't have any of that information in the warrant. So I'm unable to take any action or unwilling to take any action on the failure to appear today out of Brevard County. I've appointed the Office of the Public Defender. Were you represented by a PD over there?
No, sir. I didn't have no public defender over there at all. I didn't even hire one or nothing. That's the reason why that the FTA and warrant is issued, because I don't have a public defender there or attorney there that's represented
I got you.
at all.
Yeah, I don't have any of the dates on the failure to appear, so you're going to remain on that $72,000 bond, and perhaps the Office of the Public Defender will reach out over there, and if there's proof that you were in custody, maybe they'll reconsider that. But at this point, you're going to remain on $72,000 bail, and we'll let Brevard County know you're here with us.
Thank you very much, sir.
Yes, sir.
Thank you, Your Honor.
Cheryl Brannaman. Good afternoon, Ms. Brannaman.
Good afternoon, Your Honor.
Ms. Brannaman, you are before the court based on an allegation that you violated probation in 1991 CR 849. That warrant was issued by retired Judge Rodriguez. At that time, he issued no bond. State, do we have any criminal history on Ms. Brannaman?
Your Honor, I didn't see much history. The only thing that I could see, because I couldn't pull up any kind of actual documents either, is it does appear that she owes money in the form of restitution. But state would have no objection for a reasonable bond.
All right. This bond was issued before I was legally able to practice law, so the court's going to consider granting a bond in this case. Your bond's going to be set in the amount of $1,000, and you're going to be set before one of our circuit courts. Is this out of Osceola or Orange? Osceola, let's see.
She has a court date already set, Judge.
We've already got a court date for you, and when is that court date?
March 9th at 9:15 a.m.
So that's going to be on March 9th. What division is that?
Next, Judge.
You're going to see Judge Nix Walker in Division 201 on that date. You do have a bond, and I will appoint the Office of the Public Defender to represent your interest.
Thank you, Your Honor.
Thanks. Damon Ivy, or Damone Ivy.
He's approaching, Your Honor.
No problem. Good afternoon, sir.
Good afternoon.
Pronounce your name for me.
Damon Earl Ivy.
Got it right. Okay. Mr. Ivy, you are before the court based on 3 separate cases. Each case is a warrant issued by Judge Young. It alleges that you failed to appear. Each warrant has no bond. You're going to remain on no bond until we can get you in front of Judge Young. And I'll appoint the Office of the Public Defender on each of these cases if they weren't previously appointed. Does Mr. Ivy have a court date?
The only court date that they gave me was for the pretrial on May 5th.
All right. Your court date currently is set at May 5th. I've appointed the Office of the Public Defender. They can get you in front of Judge Young well before that, I assume.
Your Honor.
Yes.
It's come to my attention that there may have been some confusion when it comes to the FTAs. I don't know what your position or
Would you mind pointing that microphone a little bit towards you or getting closer to it? Thank you.
better?
Little bit.
Okay, I'll try to speak up. I'm sorry.
Thank you.
So, to my understanding, Mr. Ivy was in custody, and then his court date was on demand, and the day that he was released is the day that the date was set, and he was not noticed of that, to my understanding. Perhaps, Mr. Ivy, is that correct, Mr. Ivy? I was briefly told of the situation, so I don't want to mislead the court, but I also want to make sure that Mr. Ivy gets a fair shake.
I was never given a court date, Your Honor, to make it plain and simple.
Okay.
I was on demand, and I was put on PTR not over a week ago. I called in Thursday. Monday night, they put out a warrant. Tuesday, I was arrested.
Okay, hold on just a second. Let me take a look, Mr. Ivy.
But when I called into PTR and talked to everybody, I was still on demand. I never had I already signed a plea deal, so I was just waiting for a date. But I never got a date, so that's why they released me on PTR.
Do we show a history of Mr. Ivy being on pretrial release?
Judge, I don't have anything on Mr. Ivy, sorry.
There was a motion filed on November 2nd for release on recognizances or for the alternative pretrial release, and a notice of hearing was sent on November 3rd, dated November 6th at 2 p.m. And on
That was
November,
for the first 2 cases, and then I was just put on PTR like a week ago.
on November 9th, there is a PTR release order.
Which case?
On 20 CF 3028, I'm looking at right now.
All right, I've got 3423 pulled up. Let me.
Okay.
Your Honor?
Yes.
If I may explain to the court and the clerk, the PTR officer here has explained to me that on the PTR order, if there is a date that the defendant would have had to sign for it as notice, and if it says on demand, then that would have been the last information that they would have provided to the defendant, and that would have been the last notice he would have had.
And Your Honor, I see a notice of hearing plea date certain on 2/10 in the clerk's site that I don't have access to. But I do show motion for PTR granted on 2/9.
I as well see that. I see that he was released on 2/10. I'm looking at the pretrial release order, which indicates his court date is on demand. That was provided to him, and he signed for it on 2/9. The following day, the notice of plea was provided to his attorney. Can we find out from Judge Young's judicial assistant when he has a status date and when I can get a 5-minute status?
Let me see if I can Skype her.
Mr. Ivey, we're going to skip over you. I'm not entirely satisfied that you had notice of the date that you missed. We're going to contact Judge Young's assistant. So have a seat for me. I'll continue to look into it.
Thank you, sir.
Yes, sir. Gregory LaRue. Good afternoon, Mr. LaRue. Mr. LaRue, you were arrested based on a warrant that I signed. I did grant bonds in your case. The warrant was based on an alleged failure to appear for a status hearing in 2020 CF 2501. You've got bonds on that case assigned. Bond in count 1 set in the amount of $2,500, to count 2, $1,000, count 3, $1,000, count 4, $500, for a total bond of $5,000. And I believe that you probably already have the public defender's office on my case. There's a second case that you have. That's a resisting officer without violence case. That's in front of Judge Arrendis. Judge Arrendis also issued a warrant for you, the allegation being that you failed to appear. She issued a bond in the amount of $9,999. I'll appoint the officer on the public defender on both cases if they weren't previously appointed. Thanks.
Sir, when was the resisting without violence? I ain't never got no court date or nothing for that one. I ain't had one. The only one I had, I beat it because they made me read the thing while I was in here, and they dropped that charge.
I'll tell you what I know about it, or what I can figure out about it. It was a docket sounding. The warrant was issued on the 16th in 2020 MM3100. Unfortunately, Judge Arrendis was in the best possible position to make that determination when she issued the warrant for you. I don't know a thing about the case.
Yeah, I haven't received a court date or nothing for that. I ain't had that. I beat the resisting that I had before I got out, and I bonded out, I think, in January. Or no, my bad, November. I had bonded out. And I've been out on bond all that time, and I hadn't received that.
Definitely missed the court date in front of me, and I'm not sure about Judge Arrendis.
I thought it was on the 11th, and it was the 10th, and I didn't make it.
I'm taking a look. Hold on.
Judge Young's courtroom, she's in court right now. She's supposed to start at 1:30, and she's by herself. I don't know if you want me to put her phone or you can maybe talk to her or.
Oh, is it Tabitha?
Tabitha.
Okay, let me talk to her.
Hold on, the judge is gonna talk to you.
Give me just a minute. Hey, Tabitha. Can you have a sec? No? Okay. Yes. Right. They released him PTR and it said, and the notice said his next court date was on. So I think he was confused. I just wanted to give him a bond setting for status next week. It looks like the last thing he got was from PTR saying his next court date is on. Right. Okay. All right. Does he have any court dates next week? Okay, I'll take a better look at it. Thanks. Bye. All right, Mr. LaRue, I'm looking at the notice that went out in 2020 MM3100. Notice went out for the case being set for a docket sounding. I did see that it was transferred from circuit court to misdemeanor court in December. It was immediately put on the docket for 113. Looks like the hearing on 113 occurred, and the case was set for a docket sounding.
You never received the notice, Judge.
Yeah. I do see that your bondsman, Moncrief bail bonds, was noticed of the 2/16 date. The address that the clerks had that you gave law enforcement was 1795 Eastern Avenue. That's where your paperwork went.
Eastern Avenue, that's my uncle's house, and I didn't get no court date there.
All right.
For that. The only one I had was for the felony.
I got you. Well, I'm showing that notice went out both to your bondsman and your office address, and your attorney was present when that date was set in court. So I hear what you're saying. You need to explain that to Judge Arendis and see whether she'll reconsider. I heard you out. So, so your bond's going to stay at $9,999, and Your attorney will know how to get you in front of Judge Arendas pretty quick. Thanks. Donald Martin. I did see that the mail returned. Good afternoon, Mr. Martin. Mr. Martin, you were arrested based on an allegation that you failed to appear for arraignment on a driving while license suspended charge. Judge Arendas issued a warrant for you, granted you a bond in the amount of $2,999, and I'll appoint the Office of the Public Defender if they weren't previously appointed. Thanks. Trevor Reesner.
Your Honor, may I please waive the reading of the charges?
Thank you. Good afternoon, Mr. Reesner.
Good afternoon.
Mr. Reesner, I'm going to appoint the Office of the Public Defender to represent your interest in 21 CF 391A. They have indicated that you are aware of what the charges are against you. Is that correct?
Somewhat, yes.
Okay. Well, I need more than somewhat if I'm going to waive a reading. Do you want a minute with him?
Yes, please.
And Judge, there's a notice of appearance from Attorney West Tromley in that case.
West Connolly. The attorney out of Florida.
No? Of course, he's not here.
Thank you, Your Honor.
All right. Mr. Reesner, has your family hired an attorney for you?
Yes.
Okay, what's his name or her name?
West Trombley?
All right. Are they local here in Florida?
I believe so.
All right, thank you. Ms. Nadal, as a friend of the court, have you explained to him what the allegations are against him?
Yes, Your Honor.
All right, thanks. As to each of these cases, there is no bond assigned. You're going to remain on no bond. I'll note that we have received a notice of appearance of your attorney. This decision will be in the court file, so your attorney will be able to sort that out and get you in front of the trial judge to consider a bond. And which division is he going to?
Young.
You're going to be in front of Judge Young in Division 101 and have your family talk to your newly appointed attorney, and he can get you in front of Judge Young for consideration of a bond.
Judge, there's some conditions in this warrant: no contact with the victim and family, and no return.
As a condition of no bond, I guess you're not to have any contact with the alleged victim or the family, and not return to the alleged victim's residence. All right. Thanks, Mr. Reesner.
Thank you, Your Honor.
Dominique Smith. Good afternoon, Mr. Smith.
Yes, sir. How you doing?
Doing fine. Thanks for asking. You're here before the court in 2020 CF 2201 based on a warrant by Judge Nix Walker. The warrant indicates failure to appear for arraignment. Judge Nix Walker has assigned no bond. I will appoint the Office of the Public Defender to represent your interests, and they'll be able to get you in front of Judge Nix Walker to explain what's going on. Thanks. Eddie Houston. Good afternoon, Mr. Houston.
May I have a moment with Mr.
Good afternoon, sir.
Your Honor.
Sure. State, is this an added charge to an already existing case?
That's correct, Judge.
All right, I've got a stamp that says added charge. Do we know which of the charges was added?
I do not have that information, Judge.
All right.
He says the case that he's arrested for is 20 CF 3259.
Correct. All right. Yes.
Mr. Houston's ready, and we'd like to waive the reading of the charges, please.
Okay. All right. Thanks. Mr. Houston, I'm looking at a arrest warrant, has 4 counts on it, and I'll appoint the Office of the Public Defender if they weren't previously appointed. Ms. Nadal has requested a waiver, which indicates to me that you know what the allegations are against you. Is that correct?
Yes.
As to count 1, you are assigned no bond, and you'll remain on no bond. As to count 2, your bond is going to be set in the amount of $7,500. As to count 3, your bond is going to be set in the amount of $500. And as to count, $5,000. And as to count 4, your bond is going to be set in the amount of $1,000. Thank you.
Judge, I thought there were 5 charges on this, or was the state filing 4?
4 on the warrant, unless there's additional charges.
Discharge of firearm in public?
Yeah, let's not announce the charges, but I'll show you my packet. Officer Kenda. Here, I'm going to go off the record for just a moment.
Thank you, Judge.
All right, I think Mr. Houston's all set. Thanks. Matthew Houts. Welcome back, Mr. Houts. Mr. Houts, you were arrested based on the allegation that you violated probation in 2020 CF 493. I reviewed the charging affidavit of the affidavit of the probation officer. I did find probable cause for that allegation. You were granted no bond, you remain on no bond, and I'll appoint the Office of the Public Defender to represent your interests. Thanks.
Can I ask you a question, sir?
Sure.
Okay, you're the one that violated me like 2 weeks
Yes, sir.
ago.
Yes, sir.
Okay, now, is there any way I can get credit time served, any time served for that when you violated me like 2 weeks ago?
No?
I can't get so that's just dead time until now.
I'll consider any reasonable requests if you want to resolve your allegations of violation of probation, but you need to go through the violation of probation admission form. The state has a say in what they are going to recommend to the court, as well as some negotiations that'll go back and forth. So that's where we're at. I'm not, you can plead blind to me today, but I think Ms. Nadal would probably advise you that's not a great idea. What's that?
What'd you say to plead what?
Blind, which means I won't tell you what I would sentence you to if you entered an admission. So I think that your counsel would probably counsel you against making that decision until they've had an opportunity to talk to the state. I won't prevent you from doing that. You can do anything you want, but why don't you if you got some questions, why don't you run those through Ms. Nadal, and if that's your decision to admit, then we can go that route. If it's a...
Your Honor, I'm going to mute the mic for a minute, if you don't mind.
Gotcha. No worries. I want you to talk over that decision with an attorney before you do it, Mr. Nadal. I'm sorry, Mr. House. Sorry about that. Okay, thanks. Michael Sierra.
Approaching, Your Honor.
Good afternoon, Mr. Sierra.
Good afternoon, sir.
Mr. Sierra, you were arrested based on an allegation of battery, domestic violence related, and criminal mischief. I looked at the charging affidavit. This was pursuant to an arrest warrant. Judge Munyon granted you a bond on count 2 in the amount of $500. I'm going to grant you a bond in the amount of $1,500 as to count 1. As a condition of your bond, you are not to have any contact with Barbara Brotherton, and you're not going to be able to return to the Champions View Loop apartment. Do you have any personal belongings at that apartment?
No, sir, I don't.
Okay. All right. So no return, and I'll appoint the Office of the Public Defender to represent your interest. Thanks. Johnny Hayes.
Mr. Hayes is not here. He is tested positive for COVID, Your Honor.
Okay. I'd be inclined to appoint the Office of the Public Defender in 21 MM 498. He qualifies for a bond plus PTR if there was a waiver of his appearance.
Yes, sir, we waived it.
Court accepts that waiver. I find probable cause for the allegation of battery domestic violence. Court's going to set a bond in the amount of $250 plus pretrial release conditions, those conditions being that he have no contact whatsoever with Alicia Coleman, and he may not return to 8545 Bay Lily Loop. He may return one time with law enforcement if he needs to collect some personal belongings. Thank you.
Thank you, Your Honor.
You say bond with PTR?
Yes. Warren Jackson. Good afternoon, Mr. Jackson. Mr. Jackson, you are here before the court based on an allegation of battery, domestic violence related. I have taken a look at the charging affidavit. I do find probable cause for your arrest.
The victim is in jail, Judge, for this defendant.
Understood. I understand that Ms. Wilson is also there in the jail facility. Court is going to release you on $250 bond plus pretrial release conditions, those conditions being that you have no contact with Ms. Wilson and you not return to the Greenpoint Hotel address. Do you have any personal belongings at Greenpoint Hotel?
No, not at all.
All right, thanks. So no contact, no return. I'll appoint the Office of the Public Defender to represent you. Thanks.
Thank you.
Thank you, Your Honor.
Jetya Wilson.
Good afternoon.
Good afternoon, Ms. Wilson. Ms. Wilson, you were arrested based on 2 counts of battery, domestic violence related, 1 count of battery causing bodily harm, and 1 count of burglary with an assault or battery. I took a look at the charging affidavit. I do find probable cause for each of those allegations. Court's going to grant bond in count 1, the amount of $1,000. I'm sorry. Bond in count 1 is going to be set in the amount of, $1,000 plus the condition of your bond that you have no contact with Warren Jackson. Bond in count 2 is set in the amount of $1,000 with the special condition that you have no contact with Isaiah Lima. Bond in count 3 is going to be lowered to the amount of $2,500 with the condition that you have no contact with Alexa Lima. You may not return to the Greenpoint Hotel. Do you have any personal belongings still there?
No, sir.
All right. Thanks. And I will appoint the Office of the Public Defender on this case to represent your interests.
I'm sorry, Judge. I need a repeat on the bonds.
Sure, it's $1,000, $1,000, $1,000, $2,500, plus the conditions as announced. Thank you. Detective, I'll be right with you. Rivera Ortiz. I had a note that he was, okay, he's out. Nope.
He's in the hospital, Judge.
All right, I had that note that he's in the hospital. We're going to reset. Madam Clerk, should I reset that tomorrow or just when he's released? He's going to be released. He's going to be brought back before the court when available. Alyssa Shea.
Also in the hospital, Your Honor.
I'm sorry.
Also in the hospital.
All right, Ms. Shea is in a similar circumstance. She'll be brought back before the court when medically able. Deltonio Watson. Good afternoon, Mr. Watson.
Good afternoon.
Mr. Watson, you were arrested in 21 MM 501 with one allegation, that's battery, domestic violence related. Appears that you qualify for a bond plus pretrial release. Your bond will be set in the amount of $250 plus the following pretrial release conditions. You're to have no contact with Asia Allen. You're not to return to the location where this occurred, which is the Chardonnay Court address. Do you have personal belongings there?
My car there. That's it.
Your car's there? All right. You will be allowed to return to the property one time with law enforcement to retrieve your vehicle while this case gets sorted out. The court is going to allow you to have contact through a third party, that's a friend or a family member, with Miss Allen to arrange visitation and exchange of the children. And I'll appoint the Office of the Public Defender to represent your interests. Thanks.
All right. Thank
Thank you, Your Honor.
George Bernal.
Good afternoon, Your Honor.
Good afternoon, Mr. Bernal. Mr. Bernal, you were arrested based on allegations of possessing a weapon by a convicted felon and dealing in stolen property. Bonds will be set in count 1, the amount of $4,000, and count 2 in the amount of $2,500. I find probable cause for your arrest and will appoint the Office of the Public.
Your Honor?
Yes, sir.
I was going to say these charges are add-on from charges from a warrant, and I had no idea.
Okay, hold on. Wait. Before you say anything that's recorded, I've appointed Ms. Nadal. Why don't you run that by Ms. Nadal? No.
Your Honor,
Yes.
I believe Mr. Bernal understands.
All right. I know you're frustrated, Mr. Bernal. The state's entitled to add charges. I find probable cause for those new charges and granted bonds on them. And the Office of the Public Defender has previously been appointed on 21 CF 553. When's Mr. Bernal's next court date?
On demand.
Is it with me?
Hold on, sorry.
All right. You're going to see Judge Young, Mr. Bernal, and your attorney will know how to get you in front of Judge Young. If you think these charges are duplicative, meaning they've already been filed, your attorney will sort that out with Judge Young. Okay? Thanks.
Your Honor, I believe in the narrative of this report, it said that the officers were executing a warrant on 20 CF 1581, and I didn't see that there had been an IA, an initial appearance in that case.
I believe that was yesterday, Judge. These are added charges.
Yeah, I thought I remembered seeing Mr.
Yes, he was here yesterday.
Oh, okay.
All right. Thanks.
Thank you.
Diana Creighton D'Souza. Good afternoon. Ma'am, you were arrested based on an allegation of battery, domestic violence related. I took a look at the charging affidavit. I do find probable cause for your arrest. You're going to be released on a $250 bond plus pretrial release. conditions being that you have no contact with Keith Alicia, and you won't be able to go back to the property at 2407 West Vine. Do you have, hold on just a sec. Yeah, you have any personal property at 2407 West Vine?
No.
All right, thanks, no return. And I'll appoint the Office of the Public Defender to represent your interests. Jared Heavener. Welcome back, Mr. Heavener. State, there was a request for 24 hours.
Your Honor, I have the same information that the court has. I was able to read through it. It appears that Mr. Hefner was released from incarceration on February 16th.
Yeah, that's what it looked like to me.
And then failed to report to probation. So state would be asking to proceed as if this was a violation of probation for technical violations of Condition 1 and 2 of Condition 9.
Thank you, State. I'm uncomfortable with making a on-view violation finding based on technical allegations, and I think the record evidence is insufficient to establish probable cause for a willful material violation of probation. I'm going to ROR him on 2018 CF 3256. Mr. Hefner, your probation officer may seek a warrant based on these alleged allegations of violation of probation, and that will be considered by a judge. But as for right now, I can't make an on-view violation of probation finding, so you'll be released ROR. As to 2018 CF 3256, you're ordered to report to your probation officer. Thanks.
Thank you, Your Honor.
Cornelius Williams.
Your Honor, Mr. Williams had a medical issue. Can we reset for tomorrow, please?
Yes. All right, we will reset Mr. Williams for IA tomorrow. That was the last case that I had on the docket. Do you have anything else, Ms. Nadal?
No, other than going back to Mr. Ivy, please.
All right, thanks. Mr. Ivy?
He's approaching, Your Honor.
Yes, sir.
Mr. Ivy, I have talked to the clerk in Judge Young's division. It appears that the plea date was set by your attorney, but I am, based on your circumstances, not satisfied that you had non-conflicting notice to show up for court. I do note that there was no indication that the plea date was provided to you. It seems unusual, seeing that it was set by your attorney, Mr. Mendoza. The court is inclined to grant you a bond in each of these cases in the amount of $500, and you were ordered to appear in front of Judge Young on March 3rd at 9 o'clock. And that's going to be for a plea. I can't hear a thing you're saying, sorry. I can't hear you.
Judge, can you hear me now?
I can.
Your Honor, is it okay if she approaches the other side? She's on the opposite side of the setup.
Yes.
Thank you.
I'm sorry, I missed what she said.
There's a PTO officer who wants to talk.
I wanted to speak on Mr. Ivy's behalf on one of the cases. He was in custody last year from November 19th on the 20th to February 9th. So he has been in custody on all three of the cases until such time. In the midst of all that, he got released on two of his cases, which was, I believe, on, forgive me, Judge, back in December on the 7th. He was not notified enough time on one of his cases. One of the other cases, it has on the clerk's record that he has a transient delivery, which means he most likely, almost positive, that he did not get that notice. That case reference was 20 CF 3423.
Understood.
And then he was released on the 9th of February, and the notice went out on the 10th, and then a week later he got the FTA, Judge.
Right.
I just want you advised from the jail standpoint that he was not notified in insufficient time as to only one of the cases.
Okay. Based on that information, State, any input from me? Hold on just a sec, Mr. Ivan. Let me hear from the State.
Your Honor, I'm not really sure I understand. In one of the cases, he didn't have notice, but the other two he did?
Appears there was insufficient notice on one of them. He was released on the other.
Officer is coming back. I apologize as I'm not informed on this case. It's just probably in
Yeah.
his best interest.
Officer, the State has a couple questions.
Yes.
So which of the cases does the pretrial release indicate that he was not provided notice?
The last one that he was in custody on that he got released was case number 20 CF 3423.
Okay.
So he wasn't noticed in sufficient amount of time in order for him to have his notice sent to him.
Right.
And the notice of delivery on that case in the clerk's record is a transient delivery, so he would not have gotten it.
Okay. I'm with you on that case. How about the other cases? Was
The
there?
other two cases, he was previously released, but still in custody on that third one that I had just mentioned. So unless his attorney physically came to the jail, he did not get the notice. Also, in case number 20 CF 3028, this is the one, Judge, that when he did have, when he was incarcerated, we actually interviewed him while he was incarcerated. The address shown on the clerk's website for case number 20 CF 3028 is the same address that we have on file here in our division, and his mail was returned on that case, I believe. His mail was returned, Judge, on that case. And it's the same address to which we have it on file.
Okay, give me just a minute.
My apologies, Judge. That case number was 20 CF 3046. 3046. His mail was returned on the 16th of February, and then he FTA'd on the 22nd, and that, again, is at the same address that we have on file. So I don't know why Mr. Ivy did not get those notices, because, again, that's the same one we have on file when we interviewed him. So as far as case number 20 CF 3028 and case number 20 CF 3046, he should have got ample enough time because the address is the same thing that we have unless he's moved. But on that third case, he did not have sufficient amount of time. State, do you have any questions for me?
I believe that's been made clear. I understand now.
All right. Thanks.
Your Honor,
Okay,
can I be
so
reinstated?
here's what we're going to do. I'm going to ROR you on 2020 CF 3423. I'm satisfied with the explanation from pretrial release that there was insufficient time, and there seems to be in the court file proof that the transient general delivery, it's unreasonable to believe that that would have got to you. The other cases, I am going to set bonds in those cases Bond in 2020 CF 3046 is going to be set amount of $250, count one, $250 is to count two. In 2020 CF 3028, bonds be set in the amount of $150, $150, and $150. Mr. Ivy, if you choose to bond out, you are ordered to appear in front of Judge Young on March 3rd at 9 o'clock at the Osceola County Courthouse.
Your Honor,
Yep.
I've been getting PTR because I'm transient. I can't afford a bail. I'm working on getting the reason why it was so important for me to get out last week is I get Social Security. Somebody stole my Social Security that was supposed to bond me out in November. I was in the process of getting my card back so I could get some money. I have no money. I have no means of getting any money. I have no means of getting in touch with Social Security while I'm in here. That's why they PTR'd me.
All right,
So I
does
can
Ms.
get this stuff going. You know,
Was-
all I have to do is call them. I called them last week. And that address that I have is not a correct address. I don't live there. Ever since I got rearrested in November, that address was no good no more.
Hold on a sec, Mr. Ivy. Let me ask some questions of pretrial release. He was a former client of pretrial release. Does he qualify?
Because we will have to do bonds or PTR if qualified. We have to do our due diligence and
All right.
check his background.
I'm going to set bond or PTR in 2020 CF 3028 and 2020 CF 3046. I have no objection, Mr. Ivy, to you getting out on pretrial release if you qualify, and you did before, so I don't see a problem with that. But I want to make sure that me and you are on the same page, that you got to be in front of Judge Young on March 3rd at 9 o'clock.
Yes, sir. No problem. I would have been there this time. Like I said, I call PTR every Thursday, and I called my attorney Friday. He never even informed me of any court date.
All right.
So that's part of my problem. In the 919 Park Terrace Circle, I don't live there no more.
Okay. Well, I've granted you bonds or pretrial release. I RR'd you on the one case where I wasn't satisfied that you had notice, and you're ordered to appear on 3/3 at 9 o'clock in front of Judge Young. Thanks. State, thank you.
Thank you, Your Honor. Did we address Mr. Groh and?
He bonded.
Okay, and Ms. Shen?
He bonded too.
Okay.
All right.
I did not.
Ms. Nadal, that was the last of the cases that we have. Do you have any additional clients?
No, Your Honor, that's it. Thank you so much for your patience this afternoon.
Thanks for your help.
Thank you.
State, thank you very much.
Thank you, Your Honor.
Good to see you. Officer Kendo, thanks. Yes, sir. All right, deputies, detectives, if you can head on back to the jury deliberation room. I'll be back there in just a second.
I was a PD until July of last year.
Is that right? How's the switch been?